Today for the double day. She knew she had a court today.
Okay. Well, that probably finishes her community service, but she still has fines she hasn't paid.
She told me yesterday she was coming in to pay them off. She still has 2 days of community service left.
Okay. Okay, well, maybe the reason she's not here is I had written down March 27th, so let's put it on, maybe you got her on the wrong day. So I'll pass it to March 27th, which is Monday. Jonathan Carter.
Yes, sir.
19/24/35. Community service done. And you have, I'm showing $125 left on your fines. You did make a payment recently.
Yes, sir. I can't make any payments today. However, next Friday, I'm paying it off.
Okay.
After I pay it off, do I need to just call and make sure that I don't need to show up anymore, or would you rather me show up again?
No, you can, if you confirm it, you don't have to appear. I'll set it for April 28th. If it's completed by then, you don't have to be here.
Okay. Awesome.
9 a.m. April 28th.
Okay, thanks, sir.
You are. Jeannie Covelli. Jeannie Covelli is here, 02/46/67. You just have fines to pay.
Yes, sir.
Can you make a payment today?
Yes, I'm gonna make a $50 payment today, and hopefully by next Friday I'll have my income tax and wipe it out.
Okay, I'll put you down for $50 today. April 28th is your next hearing at 9 a.m.
Okay, sir, thank you.
You're welcome. Denise Faulkner,
Yes, sir.
21/15/32. She's at Riverside, and I've got a report from her.
Yes, sir.
Okay, well, based on what I see here, I think we need to have a urine screen today. So I want you to go do a urine screen, and then I'll deal with you after I get the results. So
All right.
go to your probation office and submit to a urine screen. Okay, we're going to start the arraignment hearings now. So anyone that's got arraignment, come in. That's new cases or old cases where you missed a hearing. You'll get called up. I'm going to have some instructions for you as a group, and then if you have questions as an individual, we'll go over them when your name's called. I want to explain to you your rights, which you probably have heard multiple times. It comes from a very famous U.S. Supreme Court case called Arizona versus Miranda. You have a right to remain silent. You don't have to make statements. If you choose to make statements, it's all on the record. It can be used against you. If you jump up and say, yeah, I did, the prosecutor can use that against you. You have a right to have an attorney. If you can't afford one and are facing a jailable offense, you have a right to have an attorney appointed. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Those are the rights all defendants have. If you enter a guilty plea or a no contest plea, you're waiving those rights. You should not waive your rights if you don't understand the proceedings, if you want a trial, if you want to talk to a lawyer, or if you don't know what to do. You should enter a not guilty plea. And in any of those circumstances, you need to enter a not guilty plea. Call the first case.
State of Ohio versus Zachary Truitt, case number TRC 23279 A and B.
Are you Zachary Truitt?
Oh, yes, sir.
Mr. Truitt, it's alleged that on March the 18th at 2:46 a.m. in Perry Township, you were driving a vehicle while you were under the influence of either alcohol or drug, well, actually alcohol. States alleged you took a breath test, and that the breath test you took was 13. We'll just round it off and say 13. And it's alleged to be the first time you've had this charge, or at least you've never been convicted. This would be your first conviction if you get convicted. Under Ohio law, it's progressive, so the more of these you have, the worse the possible penalties are. On a first offense, the maximum is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most the court can impose if you're found guilty. There is a minimum. which means the least the court can give you if you're found guilty is 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum penalty. Do you understand that charge?
Yes, sir.
I want to explain to you what the breath test means. Under Ohio law, if you take a breath test and you test 8 or higher on the breath test, there can be a presumption that you were impaired. It's called the per se level. It's per se against the law to drive with a breath test score of about 8 under Ohio law. But to get that presumption that you are impaired, the state has to show they complied with the rules. There's rules about giving the test, when it can be given, how long after driving, calibrating the machine. They have to show compliance with all those things to get the presumption of impairment. You understand that?
Kinda. Yeah.
Okay. It's a little bit of complication, yes. You have another charge other than operating a vehicle intoxicated. That's driving outside your lane. That's a minor misdemeanor. It's not jailable. The maximum penalty is a $150 fine. So those are the 2 charges you're facing. Do you understand those charges?
Yeah.
Do you
Yeah.
understand the rights you have as a defendant?
Yeah. Yes, sir.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed to represent you?
Yeah.
Do you have a job?
No.
You have no income?
Not right now, no.
I'll appoint Roger Smith. Mr. Smith is here, so we'll have him come in the courtroom and meet you. I'm entering a not guilty plea for you.
Okay.
And Mr. Smith, this is Zachary Truitt. He has a first offense ODI with a 13 breath test. He can sign a $1,000 signature bond. He'll assist you with that. This is your promise to come to court. You'll have to pay $1,000 as a penalty, and you get a warrant if you don't show up.
Oh, yeah. Yeah, I'll
Just come to
show
court.
up.
You don't have to worry about this anymore.
Sign that.
Sign that. You promise to come to court, and if you don't, then we got that plus bigger problems.
Yeah, I'll definitely come to court.
The computer is locked.
Sign right here, put your finger at the bottom. Sign right there, just. You qualify for it, right? Put your finger at the bottom.
Just anywhere.
Hard restart. What's your schedule like?
Let's see, Judge. Got old arms, I left my glasses back with five. Do you have a date in mind? I've got,
Probably at least 3 weeks out. Right now, I'm having to reboot the computer. It's not-
okay.
wasn't working. So I don't have the exact schedule, but if we go 3 to 4 weeks out, it should be okay.
Okay, let's see. I am here April 7th. That's a Friday.
It should be okay.
You think so?
That's, well, everybody keeps asking me, is that a holiday? It's Good Friday, but actually it's not.
We're open.
Get myself in trouble, but no, that's not a legal holiday.
Apparently it's not in West Virginia either, because I've got something at 8:30 across the bridge, so they're right there with us.
You want, so that, can you do it the 7th?
Oh, yes, yes.
Okay.
It's a pre-trial. I'll be here by 9:30.
All right, April 7th will be the pretrial in this case at 10 a.m.
So I'll be here.
You'll be here on that day? I'll call you before the whole time.
Okay.
So you're good to go today?
I'll just,
Absolutely. I'll give you a call.
State of Ohio versus Damon Pinckney, case number TRC 16-1759.
Your Damon Pinckney?
Yes, sir, Damon Pinckney.
Damon, sorry.
Yeah, it's spelled like Damon, though. Yeah.
All right, Mr. Pinckney, it looks looks like you missed a hearing back in well, it's been a while.
Yeah.
September of 2017.
Yeah.
On an ODI case. You did your community service. You still have some funds to pay, and I don't know if you did the 3-day school.
Yeah, I had to do a 3-day school, and then I did a like 8-week class or something in Kentucky, but that was just to satisfy the Kentucky side. And I really didn't even know anything about this. I'm glad, I found out this way, but I was getting a background check at my job to get hired on all the way, and they told me that this was, a thing, so I have to take care of it, hopefully,
Okay, well, there is, from the record, it looks like you didn't pay off your fines off. You did do the 3-day school.
Mhm.
You finished that. So the only thing, and you did your community service, the only thing you have left to do is finish paying off your fines.
Yeah, and I don't have the whole amount today, but I definitely can pay $100 on it, if that's okay.
Okay, see the clerk, I'll withdraw the warrant,
Okay.
and I'll give you new rehearing dates. So you're gonna come about every month until you get this done.
Right. I'm thinking the next time, I got a feeling that I'm just gonna pay it off, so.
April 28th at 9 a.m. will be your next hearing. Once you've paid it off, you can quit coming to these hearings.
All right, thank you, appreciate it.
You're welcome.
State of Ohio versus Tony L. Walters, case number CRB 2354.
And you're Tony Walters.
Yes.
It looks like from the record, you had a theft conviction in this court in January. Oh, you had a review hearing just a week ago. Looks like you missed that hearing.
Yeah, I called you in. I was in the hospital.
Did you go to Riverside Recovery? You were ordered to go there for some treatment.
No, I didn't. I've been sick and in the hospital.
All right, we have someone here from Riverside today, so I want you to speak with him. Let's get something started and set up, and after you talk with him, I'll bring you back and we'll decide how we're going to proceed. So go talk to the Riverside representative and then we'll recall.
State of Ohio versus Leah DeChambeau, case number CRB 23160.
I am, yes. Oh, I've got those too, I think.
And ma'am, you're Leah DeChambeau.
Yes, sir.
DeChambeau, it's alleged that at Rome Township on March the 15th, you were the owner of, state's alleging it was a dangerous or vicious dog, and that you failed to keep it confined to your property. That's, the charge is dogs running at large. It's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
No.
Are you going to hire a lawyer?
Potentially, yes.
Okay. How much time do you need to do that?
I don't know. Sorry, this is all new to me.
Well, I understand. I need to set another hearing date. And
Okay.
I'll give you enough time so you can be prepared when you come back.
Okay, maybe a couple weeks.
Okay. That would be, are you working
I do.
Mondays or Fridays, which is better for, those are the court dates.
Probably a Friday again.
Friday's better? Okay, we'll make it April 7th. That's 2 weeks.
Okay.
Pre-trial at 10 o'clock. If you're interested, I could have the prosecutor come out and see what they are looking for on this, so you'll have some information about that.
Okay, yes,
Let's have him
please.
do that. Let's have the prosecutor just, you stay there, we'll have him come
Okay.
look at the file and see what they are going to be asking for. if they know at this point. Mr. Hill, this is Leah DeChambeau. She's entered a not guilty plea, but it's a dogs running at large file. Thought maybe before she hires a lawyer, if the state would say it's filed as a 4th-degree misdemeanor, what the state is looking for here, so she'll have that information. Can you get that? You want to look at the file?
I need to look at the file, and I don't know if I have it here or not, but I mean, it would, one of the things is if it's an M4, then that usually indicates that some other dog or person was involved. I don't
From
know.
the affidavit, it looks like maybe it was, someone was allegedly bit, I think, is what.
I don't know, I've heard different. The sheriff told me originally that he had scratches on his hand, but then that paper said it was a bite, so I'm not sure.
So I don't know whether there would be medical bills involved, that kind of thing.
Okay.
So I wish I could give a more definite answer, but I really
All right, well, let's just wait then until the pretrial is going to be April the 7th at 10 o'clock.
Your Honor, I'm not going to be here that day,
Oh,
so I don't know to what extent, not that we won't have an able substitute here, but
well, can we do it next, ma'am, can you have counsel by next week, the 31st? The other problem is an M4, so.
Right.
I have 30 days.
so probably sooner is better.
Okay, I guess.
I'll set it for next Friday, March 31st, and there's
Oh.
several lawyers here, if you want to talk to a lawyer, that do defense work.
Okay, I'm gonna check my schedule, because I feel like I guess I have to make it work, right?
I can go longer if you want to wait.
No, that's fine.
You want to set it for the 31st?
Yes, sir.
All right, March 31st will be your next hearing,
Still at
10
10?
o'clock, and you can sign a $500 signature bond. What that means is you're just signing a piece of paper that says, I promise to come to court,
Okay,
or I'll pay $500 as a penalty for not showing up.
okay.
Just come to court, you won't have to worry about your bond. Next Friday at 10 o'clock.
State of Ohio recalls Denise Faulkner, case number TRC 211532 A and B.
Okay, are you taking any prescription medication?
Yeah, I take the Adderall and Suboxone,
Well, I see this box on here. I don't
and
know
also
if it-
take Neurontin.
Well, I'd like for your, I'll share this information with your representative from,
She told me that it might take a while to get in my system, is what my counselor said.
okay. Well, looks like you've been going for the most part to your session, so you continue to do that. I'm going to share this information from the screen with them, and I'll see you in another month. We'll make it April 28th as your next
Okay.
hearing. 9 o'clock.
All right, thank you.
You're welcome. Okay, we're ready to start the pretrial docket. I'm sorry. Okay. Yes.
State of Ohio versus Tracy J. McDonald. Case number TRC 222574, A, B, C, D, and E. Tracy McDonald.
All right, and this is Mr. Smith's case as a pretrial.
Yes, Judge, he switched treatment providers at Mahajan, I believe we have a reports.
I think he was already going there for something.
He was in Riverside or Bethesda.
Yes.
But
I'm
this-
in, Went her now, new life.
I just saw the letter.
He had been at Mahajan too.
I'm still in Mahajan.
So is he in a sober living type setting?
Yes.
Okay, well, I hope this works. I'm skeptical, but let's see. I think he's done okay as far as his sobriety, but my impression of Mr. McDonald is he likes to bark out the orders. He likes to be in charge and tell everybody around him what he's going to do. So I don't know if that's going to work. Because that seemed to be the problem at Bethesda. He had a lot of problems getting along with folks. But we'll try this unless the state's going to jump up and down saying no.
And I haven't seen the report, but from,
Well, you just started.
well, then
Here a
I
week
think
ago.
we're willing to, and hopefully he's going to take to the treatment that they want to provide, and it's going to have a positive outcome. That's what we're hoping for.
So, yeah. I don't want to see you coming back in here and saying, well, they're not doing things the way I want to do them, and I'm going to go, this is going to be the last jump. You're not jumping someplace else.
This is, I
You don't
kinda
need to
got,
say anything else.
all right.
You know what you got to do.
Will give us a
Get good reports, no excuses, none, it's not going to be their fault. It's going to be your fault
Right,
if there's a problem,
right.
okay? April 28th will be the next hearing. 10 o'clock. I want to see a good report then.
State of Ohio versus Gregory McNeely. Case number CRB 23-3.
This is Mr. Smith's case, pre-trial. Okay, it's a pretty good report. Good job.
I do, okay.
He's been at Riverside since the beginning of February. So what's the state's position on this?
As long as he's being compliant and making some progress, we would be willing to extend him some more of that opportunity.
Okay, doing well, let's keep doing well, and eventually we'll get a good result out of this. Is that a fair statement, Mr. Hill? What can you promise him down the road if he keeps, does the state know what they're looking for? If he's compliant?
We had spoken early on about a continuance to allow him to do treatment. We were looking at a dismissal of the charges if he's compliant and completes his programs. So that's what we're still on track to do.
That's a pretty good result.
All right.
Okay, so you're okay with keeping the work toward that, right? Getting an outright dismissal?
Yeah.
Okay.
Doesn't get better than that.
Not much with that.
Yeah, no probation, nothing, just, yeah, but you gotta keep it up, you're doing
One
well.
of them.
All right, we'll see you in another month. April 28th, Mr.
Be fine, Judge.
Smith. Pre-trial, April 28th.
10 o'clock.
10 o'clock.
Thank you, Judge.
State of Ohio versus Michelle D. Terry, case number CRB 22-818.
This is Mr. Smith's case.
Yeah, that's fine.
Judge, I've spoken with the prosecutor. Unfortunately, we're going to set this for trial. The issue I have is she's a nurse at St. Mary's. They have suspended her pending the outcome of this case. Is it possible to have a trial next Friday? I know that's a little bit short notice, but she's not able to work until this is resolved one way or the other.
Okay. Mr. Hill?
We're not opposed to that, Your Honor. We understand that she's having some problems with her employment apparently over this, so we want to resolve it as quickly as possible. And I would also mention, Your Honor, that I have reviewed some video that was given to us by the defendant, and probably not going to want to pursue the resisting charge, just the domestic charge.
That's my understanding, Judge, yes, after looking at the video.
Okay, we'll set this for trial March 31st at noon.
Thank you, Judge.
You're welcome.
I'll call you before then, we'll talk about it.
State of Ohio versus Tavisha Shears, case number CRB 22-578 CRA and CRA 22-634.
This is kind of a hybrid of misdemeanor and a felony, so I asked to be put on the misdemeanor call up.
All right, my notes were she was looking into Vivitrol.
Yes, she just took a drug screen. We might need to call this one back up.
Okay.
We're waiting on drug screen. We're still waiting, Judge.
All right, we'll
Thank
call
you.
back after we get the results.
Okay.
State of Ohio versus Alicia Harless, case number CRB 23-168 and CRB 23-170.
All right, and ma'am, you're Alicia Harless.
I am.
This is a minor misdemeanor failure to confine a dog. We had one previously that was a 4th degree misdemeanor, so this has no jail time. The maximum penalty on this is a $150 fine. The state's alleging that if Fayette Township, you were the owner of a dog that you failed to confine, that is a minor misdemeanor, maximum penalty $150 fine. Do you understand the charge?
Yes,
You understand your rights?
yes,
How do you plead?
not guilty.
Okay, there's actually
Yeah,
two
I was
counts.
gonna, yeah.
One is dated March 20th and one is dated March 22nd, so.
Yes.
Not guilty to both.
I mean, if I plead guilty and just pay the fine, do I have to come back?
You do not have to come back.
My dog did get out. I mean, I'll just pay the fine. But I know the problem now. It was my door. So, and I figured it all out, so.
Okay, what's the state's position? So if you enter a guilty plea, man, let's make a good record of it. You're entering an admission that the charge is true. You understand that? Is that what you want to do?
Yeah, I'll just pay the fine.
All right,
I'll just pay it and be done. She got out, it's the truth.
Mr. Hill, do you have a position on the
We don't take any position, Your Honor. We wouldn't be opposed to just one court cost.
All right. So what was the problem? You said you fixed it. What's the,
My front door, I didn't know that, I thought that the kids were leaving it open or something, and I pulled on it and it comes right open, so, we had to like drill a new door thing in and everything, because the deadbolt wouldn't even go in, so.
so the dog was able to open the door by themselves? Is that what you're
Yes, yes.
Okay.
Yep. And I was going to get all their tags. I brought those with me today. And when I came home, the game warden and the cops were in my driveway after I left and made sure that the door was shut. And the door was wide open once again. And Axel grabbed it with his mouth and opened the door. So,
Okay. Well,
but now
it is the law in Ohio, which a lot of people, especially in more rural areas, don't honor or understand, but you gotta keep your dog on your property.
I know. I brought receipts.
Or you can have them off your property, they gotta be on a leash or under restraint.
I brought receipts to even show you that I bought all kinds of new things for the yard for him. I'm sorry.
Okay. I'll accept your pleas on 23-168. I'll impose a $100 fine,
Okay.
which I will suspend on the conditions you don't have any further problems with the dog leaving your property.
Yes.
Order you pay the court costs on that one case.
Okay.
And then on 170, same thing, $100 fine suspended, and I'll suspend the court costs on 172. So you just have to pay one court cost.
Thank you.
That's bad enough, $110. Do you need time to pay that, or can you pay it today?
I'll pay it today.
Okay, see the clerk, pay your court costs, don't have any further incidents, and that'll be it, you'll be done.
Thank you.
You're welcome. Clerk's to the right, as you leave the courtroom.
State of Ohio versus Christopher Haberlin, case number TRC 191630 A, B, and C.
And you're Christopher Haberlin?
I am.
All right, Mr. Haberlin, it looks like you got arrested on a warrant and posted a bond recently.
Correct.
And this was a case, Mr. Morford was your lawyer.
That's correct.
Is that right?
Yes, sir.
So there actually was a sentencing though. He had been sentenced on this, looks like. Or not?
Yes, Your Honor, on TRC 191630,
Okay,
it was a failure to appear for a review.
yeah. I saw that, I just didn't see, there's usually the entry is not showing. There's a lot of paperwork in here that could be, let me see it on the computer. All right, the allegation is you failed to appear for a review hearing in May of 2021 and got a warrant issued. That's the reason for the arrest. Do you understand that? Do you admit or deny you failed to appear for your review hearing?
I admit it.
Do you have an explanation for not appearing?
We was dealing with some housing issues in Tennessee, and honestly, I mean, time got by me before I ever realized it.
But are you living back here now?
We actually just moved back.
Okay. Do you have new charges, or what? How did you come in police contact to get arrested on this warrant?
Me and my wife had a spout, and they actually just came to do a well-being check or whatever, and I mean, everything was good, other than the
Well,
warrant
it's not
itself.
good when you get hauled off the jail, right?
Well, I mean,
You got
yeah,
hauled off the jail.
minus the warrant part.
Okay. So you've posted a bond now.
That's correct.
All right, so what I'm going to do is it looks like
And I do have the money to pay those fines and stuff off.
you're going to pay the whole thing off? Okay.
Yes,
So
sir.
you got some community service to do?
I've got my paperwork. I gotta find it from the move back home, from doing it in Tennessee.
Okay, I'll cancel the warrant.
Okay?
I'll give you a new hearing date of April 28th, so you got a month. to get stuff together.
Sounds good.
Bring in your community service. If you need to work it off, you've got some double days coming up where you get double credit. Can I see his entry again? Was there any? Okay, you were supposed to go to treatment also, so I need some proof that you did that.
Okay. Because that's when I graduated Riverside here, right before I left.
Okay, well, I'll take any proof that you got that you completed treatment.
Okay.
There is something in the file from Hope of East Tennessee.
Yep.
Saying that you were in a program then, but that's been a while ago.
That's correct.
Okay. All right, so you know what you need to do? Because I want to make sure you're in recovery. Are you in recovery now?
I'm actually going to talk to Kathy Ross here as soon as I leave.
Okay.
And,
well, I'll be on board for that.
Okay.
They work with the courts. If you want to do that, bring me proof that you're doing treatment and that you're doing what they ask of you.
Will do.
Okay, April 28th, your next hearing, 9 a.m. I'll cancel the warrant, so you won't have, it's going to be a sentencing. It'll be a sentencing. You have the bond up now, so that's why I make it as a sentencing. If you don't show up, that just tells me that you have a bond. So rather than just, the last time you did show up, we do a warrant. Well, the sheriff is not going to go look for you on this.
Okay.
But now that you have a bond up, if you don't show up, the bail bondsman has to pay $1,500 to the court. Mr. Sowers, you know him?
Yes, sir.
He never pays the $1,500. You know why? He always goes and gets the people, throws them in the back of the whatever, and takes them to jail. So I'm just telling you that you can't blow off the hearing, he'll come get you and snag you and take you to jail.
I'll be here.
So just come to court. That's all you gotta do.
Sounds good.
Work on this and get it done. April 28th is your next hearing. It'll be at 10 o'clock, not 9 o'clock.
All right. Thanks, sir.
You're welcome.
State of Ohio versus Ashley D. Atkins, case number CRB 23169.
This is an arraignment. We're getting some arraignments as the paperwork gets processed by the clerk. They just filed this morning. It takes a while to get the paperwork processed. And you're Ashley Atkins?
Yes, Your Honor.
Ms. Atkins, it's alleged that at Fayette Township on March 17th, you purposely deprived Walmart of property without their consent. That's a theft offense. The maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
Do you want a lawyer appointed?
Yes, please.
Do you have a job?
Yes.
What do you do?
I work at Dairy Queen.
Paid by the hour then?
Yes.
How much per hour?
12.
How many hours a week?
Right now, just about 15 to 20. I work part-time and my husband works full-time. And he's about to start a job at the DEP on Monday.
Is he paid by the hour?
Oh, I'm not sure with this new job. He'll find out all the information on Monday when he goes.
Well, I have to consider your household income since you're married. How many people in your household?
3.
You have one child?
Yes.
Okay. Do you know what your husband's, do you file a joint income tax return?
Yes.
What's your gross annual income? That's what I have to look at.
I'm honestly not sure. I'd have to look.
You don't have any idea what he makes per hour?
He was making, when he was still working his previous job, was making 18 an hour.
Okay. And that was 40 hours a week?
Yes.
So he's making about $37,000 a year. Yeah. So, I mean, it may seem rough, but you're pretty close. That's pretty close to what a household of 3 can make.
He's currently not working because he doesn't work at that job anymore, and he hasn't technically started his new job at the DEP.
Is he getting any kind of unemployment?
Not right now, no.
Okay. Well, I'm not gonna appoint counsel. If you want me to appoint counsel, you're gonna need to bring in your income tax records, because you're pretty close to being over just on what he had been making. So I'm supposed to go by the gross annual income, and I'm showing him making $37,000, and $40,000 is the cutoff, so you're only $3,000 away.
Okay.
So, I'll set this for a hearing. If you want to hire counsel, you can do that, or if you want to bring me the tax records on your next hearing, then I'll reconsider whether you're eligible for a quarterly counsel.
Okay.
But if you're showing more than $40,000 a year gross income, then for a household of 3, that's more than what I can appoint counsel for.
Okay.
I have a guideline. The Supreme Court tells me I have to go by.
Okay.
Okay, so, let's set it in 3 weeks, so that'll be the 14th of April. That's gonna be a pretrial at 10 o'clock. I'm gonna let you sign a signature bond of $1,000. That's just your promise to come to court as ordered or pay a $1,000 penalty if you don't show up.
Okay.
I'm entering a not guilty plea for you. Next hearing, April 14th, 10 o'clock. If there's, did you get that? Yeah, she wrote it down. April 14th, 10 o'clock is your next hearing.
Great. Thank you.
You're welcome.
State of Ohio versus Mason DePriest, case number CRB 21-189 and CRB 21-221.
This is Mr. Steyer's case. Yes, set for pretrial. I'm going to take a screenshot. Did you see the results? See. Okay, so I want to make sure you don't have that here. All right, I have a report from Riverside. They had good screens, but I would say the report says he's making progress, but there's still things to work on. Bottom line. So my initial response to this would be to continue to monitor his progress and treatment. Is that agreeable with the defense and the state?
Yes, Your Honor.
Yes, Your Honor, it is.
April 28th is the next hearing.
I'm available that day, Your Honor.
April 28th for pretrial. Continue with your treatment, Mr. DePriest. I think you're doing well. You're on the right track. You just haven't finished it yet, so we'll just keep working at it.
All right.
Keep up the good work.
Good work. Thank you.
State of Ohio versus Jeremy Lewis, case numbers TRC 22-2562, A and B, and CRA 22-674.
All right, this is Mr. Steyer's case set for pretrial. And one's actually was filed as a felony, 22674.
We've got some. Just road schedule over here. This is Jeremy Lewis. I guess this is with Pathways.
Oh, like appointments?
Yeah. May I approach, Your Honor?
Yes. Is he still Pathways?
I don't see it in any of this, but it was a prior thing what we got from Pathways.
There's something going on with Wood County also, you're in that.
Are you dealing with Wood County or just this court?
It just said, there's several listings, Wood County cart, I don't know what that means.
Oh, what happened, before I ever got in this situation here, I was picked up on an AI in Boyd County. I went to rehab from jail here, all right, and Pathways. And while I was in Pathways, I guess I missed court.
In Boyd County?
Yeah. Well, got picked up or turned, they wrote it up like I turned myself in, but I ran into an officer that I believe that arrested me originally at the pawn shop the other day. And
Do you have court?
I had a,
Do you have a due date
no,
at that point?
no, I'm all good, I'm all squared up now.
Okay.
Yeah, but this was, it was previous to this case. They had told me at Pathways that,
So you're not reporting to the Boyd County Court anymore?
no, sir.
Well, he pled guilty to the OVI offense in October, so he's been at this a while. And then the felony is actually, it's not a possession, it's a unauthorized use of a motor vehicle. So I don't know if that was a relative or what's the situation there.
Stepfather, and in the beginning, he was furious with Mr. Lewis, and but he and also Mr. Lewis's mother wanted Mr. Lewis to get into treatment, and now he's been doing that for some time. And I don't know what today's report really shows. It looks like he'd attended a lot of sessions. I don't know if there's any other information in there about his progress.
It does not give it.
Your Honor, and Mr. Hill, I got a letter, we have a letter here from the 27th, which I guess was the last time I got a written letter, stating that he sees Pathways as a provider and does 4 hours of treatment each month and continues to be compliant. I don't have that, I don't have a letter of that sort today, but then on a previous occasion also, we got this, I basically got the same basic setup you've got there today, but attached to a fax. It just says he's keeping his appointments. So I think basically that's just a record of appointments.
I do have, apparently he went to a 30-day program. Was that inpatient initially?
Yes, sir.
Okay,
Yes,
so
sir.
he finished that, has certificate of completion on that, but he's in outpatient follow-up now, so.
And I'm not sure, Your Honor, that this is the sort of course of treatment that we're going to expect to complete. This is probably going to be an ongoing, long-term thing. I mean, the frequency may rise and fall, but I think this is probably going to be a long-term mental health treatment program. I don't think an overall completion is really a realistic goal.
Does the state feel comfortable at this point resolving, because he's pled to the misdemeanor, but the felony's still there. Do you feel comfortable resolving that at this point, or do you need further input from the relatives as vehicle was taken? See what their status is.
Well, I actually do have a thought on this, Jasmine. Because of the fact that Mr. Lewis has already pled guilty to the misdemeanor OVI charge, and we've spoken in the past with the owner of the vehicle, and they got the vehicle back, there was damage to the vehicle, but they did not wish to have restitution. We would feel comfortable today if Mr. Lewis would plead guilty to a misdemeanor theft of the vehicle and be sentenced along with the OVI as a first offense, and also taking into account the treatment that he has gone through, give him a suspended jail sentence that would be in excess of what normally would be imposed on a first OVI, and have probation. And hopefully he sticks with his program, and if he doesn't, we'd ask for a probation violation.
That's suspended on probation.
That's fine.
If the court would accept that recommendation, we would be agreeable to that, Your Honor.
Okay. So the state's moving to amend the unauthorized use to misdemeanor theft, which I think is 291302.
I believe so, Your Honor.
Do you understand that? They've amended the charge to misdemeanor theft, and it's my understanding you're agreeable to entering a guilty plea to that?
Yes.
Is that correct, sir?
Yes, sir.
Is there anything you want to tell me before I sentence you on? I'm going to sentence you on both of these. You already pled guilty to the OVI previously.
It was, I stay at mom's. I used the vehicle without their permission. I wouldn't necessarily say I stole it, but yeah, by the way the law's written, that's exactly what I done. So I can't make any excuses about it.
Okay, well, you were originally charged with unauthorized use of a vehicle, which, you know, is actually a felony, but they agreed to reduce it. And here's the only reason is my take on this. They want you to have some jail time over your head in case you have some responsibility to continue in recovery. You'll never get to the jail time as long as you stay clean.
Okay.
But if you mess up,
Your
you
Honor,
have potential going to jail.
in order to just sort of kind of clean this up a little bit in terms of the theft, because I don't think there was necessarily a purpose to deprive. Mr. Hill brought up the possibility of doing an attempt at unauthorized use instead, because I think the statement he just made is kind of more in line with attempt to unauthorized use than it is with theft, which we'll have to check. I'll look up the attempt statute real quick if I.
2923.
I didn't ask permission.
That's, I get you.
Okay, so let's go back and make sure you're on board with this. So the state, rather than have you enter a plea to unauthorized use, which is a felony, if you attempt to use someone's vehicle without authorization, then that makes it a misdemeanor. So that's what they're going to amend it to.
I think that's more in line with the facts as he just stated them, and I think as the state, I'd say he's agreeable to that.
Now, one thing, Your Honor, I'd like to ask of the court as part of this sentencing, we want to make sure that there's enough time suspended to make sure that Mr. Lewis doesn't forget that he needs to stay in his treatment. So we believe a 6-month suspended sentence is appropriate.
Anything else you want to say, Mr. Lewis?
No.
All right. All right, I'll allow the amendment to attempted unauthorized use of a motor vehicle, and you're pleading guilty to that. I'll impose a $50 fine on that. So a light fine, because I know you don't have a lot of money. No court costs, because I'll put it on the ODI. 6 months in jail, all suspended. No restitution was requested by the owners of the vehicle, so there will be none ordered. You're to continue in treatment as long as it's recommended. So you need to do whatever you need to do to stay clean. That's what I want you to do. And I want to give you some incentive to do that. So you need, sometimes carrots and sticks. So this is the stick. The carrot is doing it for yourself, because you're the one that benefits, your family benefits, the community benefits if you stay clean.
Yes.
But if you need some negative reinforcement, well, you got 6 months in jail hanging over your head too if you mess up. So just don't mess up. I don't want you to mess up.
I won't.
So I'll set it for a review hearing on October 27th. Is that right? Read this that way. October 27th will be your first review hearing. 9 o'clock that day.
Come back that day.
2 years of level 4 probation. You're going to meet with Mr. Major back with probation.
I'm sorry?
And then now on the OVI, I've got to send you on that too. Is there anything you want to say about the OVI?
No, sir.
Your Honor, is that a first offense?
It was, I believe. Yes, it was the first one. Okay, on the OVI. Well, tell me, I want to ask you a question. It says you refused to take the test. Was that correct?
Yes, sir, I did.
Why'd you do that?
I was under the influence of methamphetamine.
Okay, well, that's an honest answer. So what I'm gonna do, normally, on a refusal, I give people $1,000 fine. But I'm gonna cut you a little break because you have gone to some treatment. I'll give you some benefit of the doubt for doing that. So I'm gonna make it $700, so that saved you $300 by going to the treatment. But I think people need to be punished if they won't agree to take it. You know, driving is a privilege. If you get stopped and you're investigated for driving while you're impaired, you need to cooperate and give tests. You didn't, so it's gonna cost you $700.
All right.
License suspension was 6 months, so that's actually gonna be over here pretty quick, because it started at the time you got the offense. So your suspension will be up in April. I would encourage you to get your license back. I'll give you 20 days in jail on the OVI, suspend it all, on the condition that you do 5 days of community service. You got a couple of days that you can get coming up where you can get double credit. April 29th and May 6th are coming up. You get double credits those days. What do you think about the 3-day school, Mr. Floyd?
Well, he's done quite a bit of treatment, so we would not oppose that being waived because of the treatment he's
It's
gone
supposed to make you go to a 3-day school, which is basically like what you're doing in treatment, but it's concentrated on one weekend. It's gonna cost you about $400, I think, is what it is now. So, but I'm gonna waive it. I'm not really supposed to even waive that, but there's another $400 I'm giving you a break on because you went to treatment.
Thank you. Thank you, sir.
And I'm gonna order you continued treatment as long as it's recommended. What I want you to do what you need to do to stay clean. If you need to go get some counseling, do it. You gotta be able to do this on your own. Eventually, I'm not gonna be there watching. Now, for the next 2 years, I'm gonna be watching over your shoulder, but eventually you gotta do this for yourself.
Okay.
Okay?
Thank you.
Whatever you gotta do to make that happen, do it.
All right.
October the 27th will be your next hearing. I want you to go see Mr. Major and the probation office, which is to the left as you leave the courtroom.
Okay. Thank you.
Failure to control, $20 fine.
State of Ohio versus Brandon Miller, case number 23110 and PRC 23184.
Mr. Steyer's case set for pretrial. There's two files set for pretrial.
Your Honor, I believe the state's had difficulty reaching the victim in this matter, so they're seeking a continuance to attempt to subpoena the victim, and we're agreeable to that continuance.
How long do you need?
2 weeks.
That's gonna make it Good Friday. Well, you're not here, so you don't care if it's set then or not.
Well, no, I don't want to do that either. I'd prefer to just keep the docket as light as possible for whoever's going to come.
Well, I said we have a very devout staff. They want to leave early.
Well, let's make it 3 weeks then. How about that?
And the 14th is fine, Your Honor. Mr. Miller can be coming down from Columbus, so a little extra time between trips is not
14th
a
is
big
agreeable?
deal. Yes.
Okay. April 14 will be the next hearing at 10 o'clock.
Thank you.
You are.
Thank you.
State of Ohio versus Michael Trogdon, case number PRC 23-5, A, B, C, and D.
This is Mr. Steyer's case set for trial. Michael Trogdon.
Well, that's at first, if you mentioned something about the refusal. Okay.
I had to because I take care of two 90-year-old women, my mom and her sister, and it's probably hard for me to get here. But the reason I was out in that car, remember that real cold weather? It busted all the pipes to my aunt's house, and her furnace was in the basement. I was only way for her to heat her house.
I understand that, but that's more
Right.
Again, you got it. We can, I can probably get you, we have to do the 3-day school though, which is, be gone for 3 days to do it. These guys have.
I can do that, but I can do that, but I have to, you gotta give me time to
No,
find a nurse
you'll have to,
take care of my.
you'll set it up. Okay. Your Honor, I think we've reached a, agreed to disposition on this matter. This is, a first offense OVI. It's charged with a refusal, but discussed the factual situation a little bit. I think the state's agreeable that this was more not really a refusal situation. It's just the test didn't end up given, but it wasn't necessarily to be treated as a refusal. Although that's somewhat academic on a first offense, but just due to some circumstances. But the only thing we would otherwise deviate from the norm on this is Mr. Trogdon has some pretty serious physical limitations and transportation issues. The state's agreeable to waiving the usual community service on a first offense OVI, and we would ask that the court do that and otherwise sentence as the court feels appropriate.
All right. So, Mr. Trogdon, your lawyer saying, and what was the plea you wished to enter?
I cannot hear. I just want to know that I have that hearing.
Guilty, Your Honor.
Your attorney says you wish to enter a guilty plea, is that correct?
That's correct.
Well, I think based on what I'm reading in the report, I'd like for him to do a urine screen today before I actually sentence him.
Okay. Are you?
Have him go to the probation office, do a urine screen, and
have you do a urine screen.
Okay.
Okay. So just go out here and to the left and wait. Okay.
To the left?
Yeah, go out here to the left and wait. Thank you.
State of Ohio versus Destiny Anderson, case number PRC 22-2665, A and B. Mr. Murray.
Destiny Anderson, is there Mr. Murray?
He is here, yes. Destiny Anderson has not checked in.
Right, you're Gene Murray?
Yes, sir.
Okay. Do you have any idea where well, it's set at 11, but it is at Well, it's not quite 11 o'clock yet, so let's recall, we'll recall it after 11 o'clock.
Thank you.
State of Ohio versus James Helton, case number CRB 23111.
This is Mr. Morford's case set for pretrial. James Helton.
Judge, I'd like to ask you for a continuance of about 30 days. We just received a copy of the discovery answer. He's not had a chance to come in and review the video either. And if you'll recall, at the end of this month, I've got 2 or 3 jury trials that are going to keep me pretty busy.
Okay. How do you look the last week of April?
I'm in trial the 24th and the 28th.
Okay, well, let's go into May. First week of May.
Monday, I'm free, Your Honor, and Friday as well.
Let's make it the first. May 1st, is that agreeable with the state?
Yes, Your Honor.
May 1st will be your next hearing. 10 o'clock.
We'll ask for a time waiver.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jeffrey Collins, case number CRA 19304, CRD 191082, CRB 15606, and CRB 15606.
Okay. I think these were actually, this was actually on the review docket or sentencing today. You have bond up, Mr. Collins?
I thought it was review as well. I paid a payment last night.
I see that, $30?
Yes, sir.
A couple cases will put on review and a couple on pre-trial.
Okay. We had some mix, some pretrial, some review. Okay. All your community service is done, so we're just working on the files.
Yes, sir. I'm gonna come up here at Doubleday. You said the 29th? You said
Monday or Friday is best for you.
Friday.
28th of April. April 28th is your next hearing.
Remember, will that be for a review?
We'll just make it reviews. Looks like that's what this should be. April 28th review, so that'll be at 9 a.m. instead of 10 o'clock.
Thanks, sir.
You're welcome.
State of Ohio versus Gary Thompson, case number CRB 22526, A and B.
Your Honor, if I may, there's several urine screens in there. He comes in every week.
Okay, very good. Thank you. And this is Mr. Morford's case. Set for pre-trial, we're looking for screens that are clean. These are, I guess, acceptable screens.
I think you put him on a weekly schedule, I believe, Judge.
Yes. On screens.
Yes, sir.
Which seems to have helped. Okay, are we ready to resolve this now? what's the state's position on it?
We wouldn't be opposed to that, Your Honor. One of the victims is deceased, I believe, so, and that is Ms. Perry.
Tommy Perry, that was 526B.
So you would dismiss that one outright. The other one, in which Laura Thompson is the victim, we would, or alleged victim, we would dismiss that upon payment of full costs.
Is that agreeable with the defendant?
You have 95 days.
I can pay it Wednesday when I get paid for sure.
Judge, he's going to need till Wednesday or after.
This is set out a month. If he pays it before April 28th, he doesn't have to appear. If he hasn't paid it, he's got to appear.
How much is the fine?
Well, it'll be $135, I believe. See if there's a-
I'll pay that Wednesday morning for sure. I'll pay it off.
So it's going to be $185. 185 is the total.
I'll take
You
care of
pay,
that.
I'll give you a month.
Okay. I won't take that. I'm ready to get this over with, so I'll pay.
Me too. But you know what?
Y'all been happy to see me
I'll sit
too
here
long.
whatever cases come that day is the ones I'm going to deal with. So get it over, great. If you don't, I'll still be here.
What was the date, Judge?
April 28th. So if he's paid it by then, he doesn't have to show up.
Well, I'll definitely have it paid and you won't see me here no more.
Come by and visit if you want. We're open to the public. Anybody can come and watch. Sometimes it's entertaining to come and watch. You never know when funny stuff is going to happen. Okay, April 28th, no appearance required to pay the cost and will be dismissed.
Appreciate y'all. Thank you.
Take care of it.
State of Ohio versus William Whitfield, case number CRA 23-172, CRB 23-173.
Yeah, this is an arraignment. And sir, you William Whitfield.
Yes, sir.
All right, were you here when I explained the rights the defendants have?
Yes, sir.
Did you understand that?
Yes, sir.
Any questions about it? Okay, so now I'm going to go over the charges with you. And looks like the most serious one is the one on the top. 23-172 is a felony, and it is a possession of fentanyl. It's alleged on March 22nd of this year in Fayette Township. You knowingly were in possession of fentanyl. That's a 5th-degree felony, which means the maximum penalty is a year in jail, $2,500 fine. Case number 23-173 is a possession of a drug use instrument charge. It alleges that March 22nd, Fayette Township, you were in possession of a hypodermic syringe that you were using for unlawful or dangerous drugs. That's a 2nd-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Now, I've got copies of an ODI and the charge, but I don't have a case number on it. Do you have a case number on an ODI?
I don't,
Okay, 23-289, A, B, and C? Through A through D? E. Okay, 23-00289, A through E. Okay, the A case would be the OBI charge. It alleges on March 22nd at 1:46 p.m. in Fayette Township, you were operating a vehicle while you were under the influence of either alcohol, drugs, or a combination of those substances. And it's alleged this would be your second offense, that you had a prior conviction in 2017. Under Ohio law, on a second offense, the maximum penalty is 6 months in jail, $1,625 fine, and a 5-year license suspension. The minimum penalty on a second offense is 10 days in jail, $525 fine, 1-year license suspension. If the vehicle was titled to you, there's a mandatory impoundment too of 90 days. And it's also alleged by the state, you submitted to a urine screen. So urine screens are packaged up and sent to a lab in Columbus for testing, and it takes several weeks to get results. I don't have any results right now on what the state's alleging is in your urine. We should get that eventually, but I don't have it today. Do you understand that charge? Do you have any questions about it?
No, sir.
Okay, you've got some other traffic charges. Not wearing a safety belt. That's a minor misdemeanor. It's a mandatory $30 fine if you're found guilty of not wearing a safety belt. You're charged with driving outside your lane. That's a minor misdemeanor. Maximum penalty is a $150 fine. You're charged with distracted driving. That is a minor misdemeanor. Maximum penalty is a $150 fine. And expired plates. That's a minor misdemeanor. Maximum penalty is a $150 fine. So, do you understand the charges that have been filed against you, sir?
Yes, sir.
And you already said you understood your rights. Do you have the money to hire a lawyer?
No.
Are you working?
Yes.
What do you do?
I am a Instacart driver. It's like a gig, 1099 contract.
Okay. Are you paid by the hour? How do you get paid?
By the job.
Well, I have to determine your gross annual income, so you're going to have to help me. What do you make in an average week, month, whatever you can tell me? So
Around $400 a week. So I'd
$400 a
say.
week, that's what you take home, or?
Yeah, I'd say 300 a week, 350 a week.
Gross is 400?
Yeah, at the most 400.
Do you have children you're supporting?
No, sir.
Single person?
Renting facilities.
Okay, so when did you start this job?
Just 2 weeks ago.
What did you do before that?
I was working in different restaurants throughout. I had moved from Virginia recently to come back to West Virginia.
You have any money saved?
No.
Okay. All right, I'll find you're eligible for court-appointed counsel, and Mr. Smith, I'll appoint you to represent Mr. Whitfield. Any objection to no R bond?
Well, Your Honor, and without prejudicing the case and not assuming guilt here, we think that maybe he should be assessed for treatment, just given what's alleged, if he would be willing to have an assessment and follow through with any treatment.
If he did that, is the state willing to allow him to keep the case in this court rather than transfer it to the common pleas and go to the grand jury for indictment?
Well, we're going to be far more likely to want to keep the case here if he's willing to start off and do that. So the answer to that right now is yes, unless he's got a horrible record or something we don't know about. I don't have any indication of that. This is a second offense, however.
I understand.
He's got a Washington medical card, Judge. He's interested in doing that. He wants to, I don't recall who does West Virginia Medicaid.
Well, OVP, ProAct, Valley Health.
Somebody could
Those are
assess
his
him.
choices. I don't know we got anybody here today that can do West Virginia Medicaid. I don't think so. So let me explain this, and Mr. Smith can explain it to you further. And it's kind of this whole thing about the grand jury is kind of a mystery, especially to it's a mystery even to lawyers, but mostly to the lay public. You've probably heard of a grand jury. You're charged with a felony. In the old days, when I'm talking about hundreds of years ago, because that's where our law comes from anyway, all felonies were capital offenses at one point. So it's pretty serious business getting charged with a felony because you could be put to death for it. So the idea was, well, it's so serious, even the allegation should be reviewed by somebody that's neutral, like your fellow citizens. That's what the grand jury is. So now the difference between misdemeanors and grand juries is not that you're going to get put to death, but if you have a felony, you can go to prison. If you have a misdemeanor, you can only go to the county jail. You cannot go to prison on a misdemeanor. So what the state is saying they're willing to do, because you have a felony and a bunch of misdemeanors. If you will go to treatment and do well, you might even get your felony dismissed. But at least at this point, they're willing to keep it in this court, not send you to the grand jury to get indicted, not send you to the common pleas court, who can send you to prison if they want to. I can't send you to prison even if I want to, and I have people I want to send to prison. Some of them are not even charged with anything, but I still want to send them to prison. I can't send them there, I'm not allowed to. So you can take that totally off the table. Sir, I want you to listen to me.
Yes, sir, I'm sorry.
You can talk to Mr. Smith later.
I apologize.
He's not
Yes,
going
sir.
anywhere.
I apologize, sir.
So, because this is important stuff. You're getting a great deal right off the bat, but you
Yes,
got to do what your part.
Yes, sir.
And believe it or not, we have people that don't do their part. And then they go to the grand jury, get indicted, and then you got about, Mr. Smith can explain it further, you got like 50-50 chance of going to prison then. If you go on down to the common pleas court. You don't want to take a 50-50 chance of going to prison, do you? And you want to get clean.
Yes, sir.
So this is all, it's all good stuff. You can make it happen right here in this court. So what we'll do, now, you're living in Huntington now?
Yes, sir.
We've got about 3 facilities over there we work with that you can go to.
He says he's familiar with PROACT, and he's got literature for PROACT, so
Okay.
you want to go to PROACT?
You can go to ProAct. You got to go in there and tell them, be honest with them as to why you're here. We have people show up and say, I don't know why I'm here. The judge said I had to come here. And then they can only evaluate you on what you tell them. So if you lie to them while you're there, they're going to say, well, this guy doesn't even need treatment. Well, that's not because the person wasn't honest about what the situation was. So you got to go there, be honest, get treatment set up, do your treatment. You'll come back periodically. I'm going to monitor it. If you do well and you don't have a really serious background, the state will probably dismiss that felony down the road. And you don't have felony on your record. That's a huge deal. Because you're a young guy, you're going to want to work, you're already working. There's a lot of jobs you can't get with a felony on your record. Okay? Does that make sense?
Yes.
Okay. I want you to go get on this immediately. I don't want you to come back. I want to set it for the 14th of April, and you went on the 13th of April to ProAct. That is kind of bad faith. And I have people do that too. They're only doing it to stay out of whatever. So they're going to do things at the last minute. They're not really invested in it. Show me you're going to take this serious. So is the 14th a good date?
Yeah.
It is, Judge. Yes, Friday, 14th, yes.
Okay. You have a question?
Yeah, I'm sorry, not to interrupt you, but they impounded my vehicle when I got arrested, and that's how I work. They said I needed the court's approval to get it taken out.
Talk to Mr. Well, that's going to be tough.
Yeah, I figured it would be,
It's
yeah.
going to be impounded.
He's got a second offense, but he can talk to you about that. If he
Okay.
thinks there's a reason to do it, he can file a motion to ask
Okay.
for it to be released.
Okay.
That's a good number.
Okay. That's my number.
Yeah, there's a mandatory impoundment of the vehicle on a second offense. Okay, April 14th is going to be your pretrial and preliminary hearing. I'm going to be looking for a report from ProAct. He can sign a $2,000. Did you post a bond?
No, sir.
Okay, $2,000 signature bond. Talk to Mr. Smith further. He can fill in all the details to answer the questions you wanted to ask him in the court.
When did you show up to that hearing?
When's the next hearing, Your Honor?
April 14th.
All right, good. Today, if not today, one as soon as you can, get over there.
State of Ohio recalls Destiny Anderson, case number TRC 222665 A and B.
All right, this is set for a pretrial today. And Mr. Murray is representing Ms. Anderson.
Yes, Your Honor.
How are you this morning?
Oh, I'm not fine.
So, has there been any discussions with the state, or where are we on this case?
Yes, Your Honor, there have been discussions with the state, and pursuant to those discussions, we're prepared, my client's prepared to enter pleas of no contest with consents to finding of guilty and a waiver of stipulation to the facts.
Okay. Is that correct, Ms. Anderson?
Yes.
Is that what you want? All right, is there a recommended sentence here, Mr. Hill?
Well, Your Honor, actually, I've had some discussions with Mr. Murray about this. This would be a second offense high score, so there's a lot of stake here for a guilty finding. What we would be willing to do is, if she's willing to take part in counseling, we would delay sentencing, come back at a later date to revisit the issue of what our recommendation would be.
And that's agreeable with the defendant? So let me, some of what I just said to that last gentleman kind of applies to you, but, I mean, you don't have a felony, but you got a pretty serious misdemeanor. So what we're going to do, we're going to give you a chance to go to treatment and show me that you're serious about it. Because the main thing I think that I would like to see for you is that whatever substance use issues you've got, those are resolved. And I'm not going to see you back here in court. You're not going to drive under the influence anymore. You're not going to run into me while you're high, or any of the people that are sitting out here in the audience watching this now, and cause a problem for yourself. So now it's going to take some work. You know, we're not talking about, oh, you're going to go and do a couple sessions and come back and it's all going to go away, because that's not going to happen. I am going to sentence you, but I'm going to give you, the more I'm convinced that you've dealt with this and that we're not going to have a problem, that you're in what I would call recovery, and that's going to be a long-term thing, then the more lenient I can be on your sentence. But you're going to have to show me some work. It's going to take some work. Okay? Now, where do you have a place that you have arranged or want to go for your counseling?
I think I was gonna go with Spectrum.
Okay. That's an organization that the court works with that's here local, so that's acceptable to the court. So what will happen is you're going to go there, and then they're going to periodically give me reports as to how you're doing, and then you'll come back and I'm going to look their report, look at you, kind of evaluate, are you really putting forth an effort, are you doing good? And, you know, I'll just keep monitoring it for a while, and it's not going to be like next month. And Mr. Murray, if you're going to continue in this, you're a long way away from here, I would let you appear by teleconference if you wish to do this. So you can be on the TV screen rather than drive down here for every one of our hearings. So
Understood, Your Honor. I can do that also.
okay, well, that's up to you. I'm just throwing that out there as a possibility, because we do have, in this kind of situation, with lawyers that are not local, have some distance to come, and we're basically, it's a monitoring hearing. I would allow you to appear by teleconference rather than get in your car and drive several hours to be here, if that's what you want to do. It's up to you. If you want to do that, you would just need a laptop or even a smartphone, and we can give you the link, and you can appear that way.
Okay.
Okay, so
Thank you, Your Honor.
usually there's somebody here from Spectrum, but I don't think there is today. So I think Maddie was, some reason she was going to be off. That's the person that's usually here from Spectrum. But you've had contact with them, or?
No.
Okay.
I was planning to come here. I didn't know if I had to get like a certain one for you guys.
Well, I'd like for you to use someone that's works with the court. Spectrum is one. Now, there's people that are here today from other agencies, and I think it's good to strike while the iron's hot. So if you want to start it out today, you want to talk with someone today to get things started. How do you pay for medical services? Do you have medical insurance, a medical card? How's that going to happen? Because it's going to have to be paid for.
Melina.
I'm sorry?
Melina.
Is that through the state?
I think so.
Melina, that's, all right. Mr. Gwynn, he's from Riverside Recovery, and that's a local agency, so he'll talk with you and get you set up. And then let's come back, I'm looking maybe well, how about the 14th of April? Is that a good date, Mr. Murray?
Yes, Your Honor, that's fine.
Sanderson, so I'm going to see you back on April 14th, and I'll get a report then as to how you're doing. So I want you to meet with Mr. Gwynn today. He'll get you set up and figure out how this is going to start, and then you'll come back. I'll get a report then, But today, I'm accepting your no contest plea and making finding him guilty. But I'll delay sentencing, so it'll be a sentencing hearing on April the 14th. And you'll come back for several sentencing hearings while you go to treatment, and they're just going to keep giving me reports. And hopefully they're all good. That would be the best thing for your case legally, that you get good reports. I think it's the best thing for you personally also. Any questions? Okay, thank you. April 14th, 10 o'clock.
Thank you.
You're welcome. That's all.
State of Ohio versus Mary and Perry, case number CRB 23-176, CRB 23-175.
This is an arraignment. So, ma'am, are you Mary Perry?
Yes.
The bailiff is bringing you a copy of the charges file. There's actually two. First one is 23175, case number. It alleges that on March the 9th of this year, in Fayette Township, you purposely deprived Walmart of property without their consent. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. 23176 case number, also a theft offense from Walmart, just a different date. It alleges it's March 23rd when this occurred. Still a first-degree misdemeanor, same possible penalty. Do you understand these two charges, ma'am?
Yes.
Were you here when I explained the rights of defendants? Yes. Did you understand that?
Yes.
Any questions before you enter pleas?
No.
What plea do you wish to enter?
Not guilty.
Do you wish to have a lawyer appointed?
Please.
Do you have a job?
No, I'm disability.
Social Security? Is that your only income?
Yes.
All right, I'm going to appoint Mr. Morford to represent you. About the 14th of April, Mr. Morgan. I know you got several trials set. Are you open then, or?
I think so, Judge. I'm here then, Judge.
Okay, April the 14th is going to be the pretrial, and that will be at 10 a.m. April 14th. And she can sign, she's posted bond. She's already posted bond, so it's continued.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kimberly Thompson, case number CRB 23177. Kimberly Thompson.
Yes.
And ma'am, you're Kimberly Thompson?
Yes, sir.
Ms. Thompson, and the bailiff just handed you a copy of the charges, I believe. You have one charge alleging that on March 23rd of this year in Rome Township, you knowingly caused or tried to cause physical harm to Tyler Dotson. The charge is assault. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail and a $1,000 fine. Do you understand the charge, ma'am?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you wish to plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
No, sir.
How do you support yourself?
I do odd jobs around my trailer park to be able to make money.
Okay, how much do you make in an average week?
Not even 50.
I'll appoint Mr. Steyer to represent you. Mr. Steyer, this is Kimberly Thompson. She has an assault charge. She has a bond up. The bond will be continued. Is there any type of protection order sought here?
I'm sorry, Your Honor.
Is there a protection order sought?
Yes, Your Honor, and we've made a mistake on the complaint as far as the name of the victim.
Okay.
It's Melissa Calicote.
So are you moving to amend?
Yes.
All right, the complaint alleges Tyler Dotson as the victim, and it should be Melissa Calicote.
That's correct.
All right, so I'm going to strike Tyler Dotson and insert Melissa Calicote as the alleged victim. And so I'm going to order, the main thing that the court wants to see happen, ma'am, is that there's no further allegations while the case is pending of a problem.
Yes, sir.
So is there any, or is it okay for you to stay away from Melissa Calicote?
Yes,
You're
sir.
not living together or anything like
No.
that? Okay, so I'm going to order that you not go around her. I want you to contact her. I don't want you to post stuff about her on social media because I want things to calm down, not
Okay.
be any further allegations.
What about her,
What about her what? I'm sorry.
her coming past my house, having a confrontation with us? She came back after I went to jail last night.
Okay, well, she's not here, so I can't order her to do anything, but here's what you need to do. You can talk to Mr. Steyer, he's going to be your lawyer, but I think this is an area I feel comfortable giving you some, it's kind of like legal advice, but...
More practical advice.
If you see her, and I know it kind of violates the current mood of the country and what people want to do, you need to retreat. If she comes to you, you go inside and call the police and say, there's a trespasser on my property. You don't handle it yourself. You don't confront her. You don't get in a fight with her. You just say, you can say to her, I have a restraining order. I'm going inside, you leave. Stay away from me. Go in, if she doesn't leave, call the police. That's how they handle it. Okay? Don't stand your ground. It's not a popular thing to say anymore. It used to be the law, that you could only stand your ground in your castle, the castle doctrine. Now you can stand your ground anywhere. You can pick a fight with somebody, you say you're scared, you can shoot them. That's the law in the state of Ohio, unfortunately. Okay, when are we coming back? When's the next hearing going to be?
Your Honor, we had set something for the 14th already. That might be a good day to come back on this.
April 14th. Pre-trial at 10 o'clock. The bond is continued. Not guilty plea is entered.
April 14th. Yes.
State of Ohio versus Ronald Smith, case number CRB 23178 and CRB 23179.
Sir, you Ronald Smith.
Yes, sir.
Mr. Smith, I'm going to go over the charges with you that you have. I think you were just handed copies of them, were you not?
Yes, Your Honor, sir.
Yes. So there's two charges, and the case numbers on them are 23178, 23179. 178, well, they're just two counts of the same thing, just different days. They're both theft offenses from Walmart that allege that the first one, March the 9th, in Fayette Township, you deprived or tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. The 179 case alleges everything that I just said, except it alleges this happened on March 23rd, a different day. So Same possible penalty as the first case. Do you understand these charges, sir?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
You want a lawyer appointed?
Yes, sir.
Do you have a job?
Yes, sir.
What do you do?
I'm an LPN.
Okay, are you working at a hospital or where you work?
I work urgent care.
Are you paid by the hour?
Yes, sir.
How much per hour?
21.
Well, you're probably not going to be eligible, but I'll figure it out. How many people in your household?
Family of 4.
Total of 4? Okay. Is one your wife?
Yes.
Does she work also?
No.
Okay. Well, maybe, let's see what it is. Are you working 40 hours a week?
30
How many hours a week?
36.
Okay, I get your gross annual income is a little less than 40,000, 39 something. Does that sound right? Okay, for a family of 4, you actually are eligible for court appointed counsel. So, Mr. Stratton, I'll appoint you. Now, we had a very similar companion case, so we need to set the same date.
I would think so, yes, sir.
You know what that date is? Because I don't remember.
14th, maybe?
Yeah.
Was it 14?
The defendant's name, I'm not sure.
It is the 14th.
Said a lot on the 14th.
Okay. April 14th will be the pretrial in this case. He can post. Now, was the other person your wife? Okay.
No.
They're going to say that she may be eligible then too, if your wife. Okay. He has posted bond, so his bond is continued.
Okay.
He has a bond up.
All right.
Not guilty plea is entered.
April 14th, correct?
April 14th, 10 o'clock.
All right, thank you.
You're welcome.
State of Ohio versus Robert Pritchard, case number TRC 222784, A and B. Your Honor, this is a Pritchard. I'm hoping that Mr. Holt is not here, but the prosecutor does have something to say on this case.
All right, this was Mr. Holt's case, and have you been in touch with him, Mr. Field?
Yeah, as a matter of fact, he just texted me again, and I just wanted to make sure we brought it before. I didn't want to just present an entry to the court, knowing that you generally want to hear from everybody.
Right.
And it was our intention to dismiss the charge if Mr. Pritchard completed the DIP school.
Which he did do March 16th through the 19th of this year.
Yes, and so we're willing to go ahead and do that. We had discussed with the court at an earlier date that there were several difficulties in proving the case. It was a crashed vehicle that apparently had been there for several hours, and by the time the police actually encountered Mr. Pritchard, it had been quite some time since the alleged incident, and we don't have any field sobriety tests. Actually, we have horizontal gaze nystagmus, but no other field sobriety tests and no other way to prove that he was impaired at the time of the crash. So that was our basis for dismissal.
All right, Mr. Pritchard, the state's saying they're willing to dismiss your case today without your lawyer being here. We can wait until he's here if you want, or I'll dismiss it today if you're agreeable.
Get it done.
Okay, I think that makes sense.
Yep.
Case will be dismissed at the state's motion. You're free to go, sir.
Thank you.
State of Ohio versus Terry Qualls, case number CRB 23139, TRD 143164, TRC 142489, CRB 141173, and TRD 132491. He is not here.
Terry Qualls was supposed to be arraigned today, and he also had, I don't know how he didn't get arrested. It looks like he had warrants out for him. See who was the arresting agency, citing agency. Sheriff's Office. How's that happen? Gary Calls has warrants outstanding, he got a new assault charge, and they're,
I don't think they can track the warrants in his desk.
okay. Well, he'll get a warrant from this, on this charge as well. We've got 1, 2, 3, 4, 5, 6 files now.
State of Ohio versus Taylor Bryan, case number CRB 23-112.
Do you have an attorney today, Ms. Bryan?
No, I was actually going to see if you would reconsider appointing me one because I dropped down to part-time now.
Where are you working?
Diversified Assessment and Therapy Services,
How many hours a week are you working?
20,
And what's your pay?
12 an hour.
Okay. All right, you are qualified then, and is Mr. Tyler Smith here? I'll appoint him to represent you. All right, Mr. Smith, I'm appointing you, this is on a theft offense, misdemeanor. Appoint you to represent Ms. Bryan. How about the 17th of April, are you available then?
Yes, Your Honor.
Okay, April 17 will be the next hearing, pre-trial, 10 a.m.
Thank you.
You're welcome.
State of Ohio versus Brian Webb, case number TRD 213514A and B, CRA 2832, TRD 2261, TRD 201555.
Mr. Murphy's case, set for pre-trial.
Judge, may I approach?
Yes.
I have a test in one spot. I think she was right.
It's supposed to be on months of them. It's worked over time.
He's been at this he's had some ups and downs. But he's been at this for a while. I'd be willing, I don't know what the state's position is, if he did a clean screen with us today to dismiss the 2832.
We would be in agreement with that, Your Honor.
Okay, go do your screen, we'll get that knocked out, it's clean.
State of Ohio recalls Tanisha Shears, case number CRB 22578 and CRA 22634.
Okay, she's still testing for methadone. I thought she was gonna work for getting on Vivitrol, is that right?
Yeah,
Okay, that's still in the works?
we actually have her on this TCC.
She's gonna go to Foundations and then back to Public Health.
Okay. When's
Her
that?
appointment's Monday morning.
All right. So they can do that at Foundations, and
Yeah, we can detox from methadone.
what's your level now?
It's 35.
35, okay, so that's what they gotta get to,
We went up to 130.
oh, wow. Okay, I didn't know, so I'm learning something, I didn't know you could get that high.
There's some variables, but yes.
Okay, well, I think that's good progress. So keep monitoring then?
As far as I'm concerned, Judge, yes, she seems to be doing the right thing.
Another month, April 28th?
I'm here that day, Judge, yes.
All right, good luck, Ms. Shears. I think you're on the right path. Preliminary hearing, April 28th.
State of Ohio recalls Tony Walters, case number CRB 2354.
Okay, so with Ms. Walter, she is going to go to Riverside?
Yes, Your Honor, I have her set up Monday morning.
Okay. You're all set for that? Know what you need to do?
Yep.
All right. Okay, I'll set you another review hearing. Let's make it April 21st. Will be your next meeting. Expect to get a good report from Riverside. You are. Okay, we're starting the preliminary hearings in
State of Ohio versus Joseph Cup, case number CRA 2159 and TRC 2048 A, B, and C. Joseph Cup, did not check in, Your Honor.
This is Mr. Stein.
Your Honor, if I may, Mr. Cup was ordered on March the 6th to do some community service for his actually international cup.
I have no information regarding Mr. Cup.
Well, he has a felony pending, so I guess the choice is either to keep it here or send it to the grand jury, keep it here with a warrant. How's the state want to proceed?
Well,
Possession of heroin was the charge.
Tempted to runneth this case over to the grand jury. It's a ton, but, yeah, I guess that's
Send it to the
probably.
grand jury?
Yes.
Well, you get the best of both worlds. Best of both worlds. We can issue a warrant on because it's the OVI was an older case. It's not, doesn't arise out of the same set of facts. So we can do a bench warrant from here on the OVI and send the other felony to the grand jury.
On the OVI, was he sentenced already, or?
He was. Yes, he was. Back in 2020.
Well, maybe it
was the first offense.
Maybe it's better to have the warrant from here on the felony charge, just because of the fact that he faces consequences here already.
Doesn't matter to me whatever the state's preference is.
Oh, we might as well leave it here.
Okay, warrants from this court on both cases.
Thank you, Your Honor.
Here.
State of Ohio versus Jeremy D. Jenkins, case number CRA 22816, CRB 22817, TRD 222781, A, B, and C.
It's Mr. Morford's case. Jeremy Jenkins. Yeah. Looks like there's been progress made. Very good. Continue to monitor.
14. Is that bad day, Judge?
Let's go a little further out. Let's go to the 21st. April 21st will be the next one. Okay, keep getting good reports. You're on kind of probation because of what happened at Bethesda, so let's get some good reports, and you're doing what you need to right now. That's all.
Thank you.
State of Ohio versus Travis Salyer, case number CRA 22791, CRA 22418, CRB 22420.
It's Mr. Morford's case. I like the tie.
Thank you.
You're welcome. And you got a report? Good. Okay, I like this sentence. Travis has made consistent and exceptional progress toward his recovery goals. That's a good word, exceptional. Outside the ordinary, better than most is the way I would characterize that. So I think one of the things I had noted today was the issue of, you still have a monitor on, right?
Yeah.
Okay, I think we're ready to take it off. So I'll order that removed. Because I think you're beginning to adopt this as your own plan rather than one that's imposed on you. I mean, that's what it needs to be.
Yeah.
For this to work long-term, it's got to be you.
Yeah.
It's not coming from me. It's got to be coming from inside you that you want to do this. And you've got a lot of reasons to do it.
I got 5 reasons, 5
We talked
plans.
about that the last time, right?
Yeah.
He carried the little one in, if I'm...
I saw that. And I just went, we're always learning, there's always new stuff to learn. And Mr. Hill and I went to basically school last week, and we found out, you know what? Kids, and you guys are really young, all right, sitting back there.
Yeah, 3 months
I
old.
think we've kind of tended to think, well, if they're really young, they're not, their parents are using it, doesn't affect them.
Oh, it does.
0 to 3 is when the most effect is happening to children of folks with substance use, although it doesn't quit at 3. But that's when the brain's developing. Most brain development occurs 0 to 3. 0 from birth to 3 years of age. So you're helping, by getting clean, you're going to help your kids, especially this one that right now is in the most progressive part of their brain development. So that should be a high motivator for you.
I understand. I've been trying to do my best.
Okay, well, I appreciate you dressing up, so that's
Thank you very much.
unusual these days.
I believe last time I was here, we talked about getting the monitor off and possibly getting the charges dropped.
Well, we're going to take the monitor off. I don't know about getting the charges dropped at this point, but what's the state's position on that?
Well, we don't want Mr. Salyers to think that we don't appreciate the progress he's making in his effort to come before the court dressed as a gentleman and bring with him a good report. So we want that to continue. We're not quite ready to say it's time to dismiss the charges, but certainly he's earned the right to not have the monitor on anymore.
Yeah, your charge originated December 15th, so you're doing good. I see improvement since the last time, because I don't know if it was the last time, but at one point there was a little attitude on your part because you wanted to do things your way.
Yeah,
So I see a little more amenability to admitting that maybe you need to make some changes. But December, that's not very long in the scheme of things for treatment from December till now, so I wouldn't be agreeable to it being dismissed. You got some time to go.
Yes, I understand.
Okay.
There wouldn't be no way that I would be able to complete through outpatient, is there? So I could get back to
Well, when your
working.
provider tells me, and I know you've got children to support, so that's a consideration. But I also, back to what I said before, what's more important for your kids than you supporting them right now, and I think that's important, that's really important, but you being clean is even more important than that. So whatever it takes to get you clean, and that you're going to stay clean.
Yes.
That has to be number one above everything else.
Yes.
Because it not only affects you and the mother of your children, it affects your kids, it affects, you got parents who are still living?
My mother.
It affects them, your siblings, it affects the whole community.
Yes.
Your substance use affects everybody, not as much as it does your kids. But we don't get the benefit of what you could do if you were clean.
Yes.
And we have to pay for you having a substance use problem. I'm talking about the community, because it usually costs money, whatever it is, whether it's getting you in treatment or people that are in jail, whatever. It's a drain on the community. It's not a plus for the community, for sure. So
Your Honor, this is the
we
first
want
time.
you to do this, and it's going to stick, that you're not going to be coming back.
Yeah.
Okay, Mr. Healy?
Agree with everything that the court has said, Your Honor, and we don't have a problem with the continuance to, I guess, the latter part of April.
Okay, I'm going to order that the monitor come off. You can see Mr. Major about doing that today.
Okay.
But I want you to stay in treatment until your provider says, oh, he's ready to go outpatient. And I don't hear that. I don't see that in the report.
Okay.
And don't start harassing them about, I want it to be the true recommendation, not something that you harassed them into doing. So let's come back in about a month.
Okay.
But as I remember, last week of April is bad for you, right?
24th and 28th, I'm in jury trials, Judge.
May 1st? I think I already said something.
Yes, sir. That's a good day.
All right, I don't want you to get discouraged, Travis. You're on the right track, but you haven't finished yet, so.
Okay. Now, may I ask, am I ordered to complete the program or?
Yes.
Okay.
You've got a felony.
I understand.
If you want the felony to go away, you got to complete the program.
I understand.
Don't even think that.
Yeah.
That's out of your mind.
If you don't want to complete the program, then you're going to leave me. The case is going to go to the grand jury, get presented by one of probably Mr. Field's colleagues. You will get indicted. because I used to be a prosecutor, and you know the saying about prosecutors in the grand jury? They can indict a ham sandwich if they want to. If they no-bill a case, it's because they don't want an indictment. They can get whatever they want out of it. They're meeting in secret with a bunch of people and then telling them what to do. They're going to indict you if they want you indicted.
Understandable.
So you don't want that, do you?
No.
Okay. Well, then you got to stay here and keep doing what you're supposed to do.
It's understandable.
Okay. May 1st is your next hearing, 10 o'clock.
Thank you, Your Honor.
Thank you. Thank you.
Okay.
Very much.
State of Ohio recall Brian Webb, case number TRD 213514 A and B, CRA 2832, TRD 2761, and TRD 201555.
No.
Do you have a script for that? The script for that? This has been a recurring problem.
Well, it looks like we got more work to do. And I really am surprised, and I guess you can tell by my, because I thought it was going to be fun.
I slipped, Your Honor.
Okay, well, we need to redouble our efforts and I don't know who One Stop Family, that's not the Family Medical Center, is it? Yeah, I guess it is. That's where you were going, right?
Yes, Your Honor.
Well, you want to continue to go there or what?
Yes, sir.
Okay, and I want you to tell them what happened. In fact, I'm going to text them a copy of your screen. So, all right. Back to work. Well, I don't want to wait till May, so Mr. Milford, let's get a date earlier in April. You can't do the last week. How about the 17th of April? That's a Monday.
I'm here.
April 17th, will be Mr. Webb's next hearing.
Get that sheet for your system.
Thanks, Your Honor.
You're welcome.
State of Ohio versus Keith Cooper, case number TRC 21-121A and B, and CRB 21-288. Keith Cooper. Did not check in, Your Honor.
Cooper, do you have any idea where he is?
No, Judge. I believe that the last time we were here, February 24th, he told you that he had written the wrong date down for the hearing prior to the 24th. He paid $20 in and was told to get his fines, community service done, and come back today.
And he has a bond up now.
I think that's because of
Prior
an
release.
earlier failure to appear, Judge.
Yeah, it was in January.
Yes, sir. Yes, sir.
Okay, I'll release the hounds.
Got it.
Or hound, I guess it's one. Mr. Sowers.
He might actually.
I'm sure he's got a whole kennel.
Refer to that in our salary.
Yes, different variety. Okay, bond forfeiture hearing on April 21st.
State of Ohio versus Ronald R. Spears, case number CRB 2140.
I'm sorry.
No. Mr.
I don't even want,
Workman's
don't even want to see it.
case, and it is all right, I think we're just,
Paying it
doing
all.
this so he can pay off the funds.
Yeah,
He has 50, Your Honor.
yep,
Yes, 50 today?
yeah.
Yes, Your Honor.
All right. May 1st,
That's good here, Judge.
pay it off and you can quit coming to these. May 1st is the next hearing, sentencing.
Hey,
Thank you, Your Honor.
State of Ohio versus John McCoy, case number CRB 21744.
I have this as, well, I think it was your case, was out for sentencing because of a bond that's posted now.
I think so, Judge.
Just has 2 days of community service there.
Your Honor, if I may, on February 27th, he was ordered to be here on March the 4th, and he did not show up.
I showed up the next Monday, the following Monday. Mr. Sowers called me and reminded me, and I showed up the
Yeah,
following.
but I don't think you did any community service, did you?
No, I had a chemical burn here that I was nursing here this last month, and I'm able to do it now. So if I can be here tomorrow, it's fine with me.
All right, Mr. Smith,
Be fine, Judge. If he wants to let him work, he'll work.
What time?
April 28th will be your next hearing, get it done, you don't have to come back.
There.
Josh, what time does he show up tomorrow?
7:30.
7:30.
Thank you.
Okay.
Thank you, Judge.
Fines are paid and costs. April 28th,
State of Ohio versus Randy C. Jackson, case number CRC 221401, A, B, C, and D, CRB 22689.
Tyler Smith's case,
Counselor.
and pretrial.
She's been, so I've been talking to John. And, Katrina.
You changed counselors.
Well, no, she's left. They don't know where she is.
The counselor was.
Yeah, apparently.
She no longer works there.
Okay.
And they don't
Her
have
name
a
was
promise
Michelle.
just
and I-
whoever does
Trees.
who's
Oh,
able to get in
Spectrum.
touch with Michelle.
I've been calling up there.
So, but he's still involved with Spectrum, but he's been waiting for them to call him to come in to set him up with another counselor, so.
Is he doing okay?
Yeah, he's been doing great.
Okay.
Yeah, I just got off the phone with Spectrum again. I talked to Katrina and Johnny was supposed to be calling today, but I told him that we're in court and we needed some kind of progress, but they don't have one to do. So, because she no longer works there.
Okay.
So I think they were short on counselors. So that isn't his fault. You know what I mean?
Sure, I understand. We've gotten some information, Your Honor, that Mr. Jackson, now Mrs. Jackson's here and reports that he's doing well, but apparently he's lost his counselor.
Well, I think Spectrum's lost their counselor too. They
Yeah,
can't
they-
find the counselor.
Well, she no longer works there, and they've been trying to get in touch with her because the last time that he was there, she was supposed to be finishing up so that he could graduate from Spectrum.
Right.
So,
And so I guess they're gonna, you're working with you, Katrina or Johnny?
Johnny.
Johnny, okay. So we'll probably just need to set another date to come back and hopefully by then we'll know whether he's close to completion or not.
yeah, because Johnny's supposed to be calling him today after lunch, so.
Mr. Hill, are you agreeable with that?
Yes, and it looks to me like he's had consistently good reports here in the recent past, and we want him to continue that, and maybe Spectrum will be able to, in the not-too-distant future, recommend that he's completed their program.
Okay. Yeah, that would be helpful for two reasons. One, because I think you want the domestic violence dismissed, and we need that. And then also, this is a second sentence, he's already pled guilty, and if I'm going to give you consideration on that sentencing, I'd like to see something saying you completed before I do that. So how long do you think it'll be before we can get that kind of report?
Do you know how close you are to?
I'm not sure. I've been there for almost a year or something, but you know, with the new guy, I'm not sure.
Okay. Yeah, he's not really sure since he'll be getting a new counselor how much longer he'd have.
Can I do that a month then?
Yeah, that probably would be best. And hopefully he's completed by then. I mean,
What's your schedule last week of April?
I am available either the 24th or 28th.
What's better for you, Mr. Jackson, Mondays or Fridays?
Mondays.
Mondays, okay, we'll make it the 24th.
Okay.
April 24th. That's a Monday. It'll be the next hearing for sentencing and pre-trial. Sentencing on 22-1401, pre-trial on 22-689.
Thank you.
You're welcome.
Thank you, Ron.
State of Ohio versus James McClaskey, case number TRC 19975, A, B, and C, CRB 19274.
Your Honor, this is just payments. How much can you pay today?
I got 20 on me.
20. He's going to pay.
Checks for a minute.
He's going to pay 20 today, Your Honor.
He's got community service to do too.
Yeah, I got some in, like I was telling you, but I'm trying to get hold of him, and they said he's out because doctors, they said he'd be back sometime this week coming.
Who's that, who we're talking about?
I forget his name. He's over to Bloom Township.
Oh.
But they said he's out with doctor's appointments, or he's got cancer or something.
What's your schedule end of April, Mr. Stratton?
Anytime, Your Honor.
April 24th.
April 24th, just fine.
For sentencing. 10 o'clock.
State of Ohio versus Kara Hearn, case number CRB 2381.
Your Honor,
Well, it's better. It's not where we need to be, but our screen's better, okay, than it has been.
well, we did get a screen done, Your Honor?
Yes.
Okay, good.
I need to form a support system.
Well, I've got a place I can send you where you can go inpatient and take the child with you. I've already talked to them and they're willing to take it.
I can't do that right now. Honestly, somebody called CPS on us yesterday. And,
Well, that was me.
was it?
Yeah. I'm concerned about your child.
There's no domestic violence. There's none. My
Well,
husband does come
but
off
there's-
a little overbearing.
There's substance use in the household, and that's a big problem.
It is.
So,
I didn't
that's
understand how.
Really, I'm concerned as much about him, if not more, than I am about you.
I didn't understand how
I just want somebody monitoring the situation there.
much work
He's
that.
gotta be taken care of, your child I'm talking
Yeah,
about.
we met with her yesterday and today, and she said, that once I come here and figure it out, she would work with us through that too. I explained to her that, I need a little bit more of a support program, support from, counselors, from friends. I don't have any friends that I talk to.
Well,
know
Miss
anything
Kim will
about-
be your friend, why don't you, Kim?
Oh, we talked to her out there at length.
Where do you live?
In South Point.
How often is she coming in for treatment?
In the morning time, I go from 8:30 to 10:30 for a group, and then I do my individual. They say I can't do 2 groups in a day there. If I had a group that I could do in the evening time, that would help. Maybe if they can make an arrangement.
And Juanita is here from Thrive. So
Okay.
this is welcome. This is your first day here, right?
Yes.
Okay. Well, let's get you, there's a group called Thrive that is peer recovery coaches. So that, as I understand it, and Juanita will talk to you about it further, they'll give you someone that you can call anytime.
That would help a lot too.
You can call this person at any time and talk about what's going on with you. And this is someone who has been through what you're going through and has been successful at it. So this will be in addition to what you're doing with Bethesda. So this is someone like in the evenings when you're having a problem or whatever, you just need somebody to talk to, you can call them.
That works out a lot, because I'm calling a
Now, if
counselor.
this doesn't work, I've got a program that I can send you to with your son, where you can both go to.
I need my husband involved in it, some family.
Well, he can't go, but you
I
and
know.
your son could go.
I know.
They'll take women and their children into this program at Marshall Health.
Because I'm telling him that I have to learn a new way to change, and he's looking at me like, if I gotta change, I don't know how.
Well, he's here, you need to support her.
He does support me, we just don't know the steps, and I'm
Well,
trying
maybe he
to,
needs to learn some new stuff too.
that's what the family counseling, I'm working with my counselor now to,
So why don't you, Kim will talk to the both of you, and see if we can't help the whole situation with the family. I thought a lot about you, your husband, and your child, and it's a situation that's on my mind a lot. I want to see you be successful, and there's a lot there to deal with. So we want to get you the help that you need. and there's more help available, but it's gonna, I know you don't wanna do it, but it may require you going to inpatient. We've talked about this before.
No,
And I know you didn't wanna leave your son. Well, I found a place where he can go with you, to
no,
inpatient.
I'm willing to put the work into everything.
Okay, well, if we're gonna make the outpatient work, and I'm gonna say this is progress, you're still testing for something I don't want you to be testing for, but you dropped off 2 or 3 other things, so that's improvement. So let's keep working at it, but if you can't do this, we're gonna have to consider inpatient.
Yes, Your Honor.
Yes, I can do it.
Okay,
Thank you.
and I wanna see you, next week. If you're, what's your schedule? Can you be here Friday?
Yeah, yeah.
Okay, next Friday is the 31st.
Yeah.
I want to keep a tight schedule with you, because I'm really concerned.
March 31st.
All right, sentencing hearing, March 31st.
Talk to her.
Talk with Kim and Juanita before you leave.
Thank you.
State of Ohio versus Heather Chin, case number TRD 2017-61A and B, TRD 2017-11A and B, and TRD 2010-86A and B. Heather Chin. You did not check in, right?
Well, that's disappointing.
Found that asked when her hearing was, either yesterday or the day before, and I went over it with her. Discussion as to whether it was a review hearing or sentencing. She thought it was a review, and I explained the reason it was a sentencing.
Yeah. Okay, well, and she has a bond up, I believe. Let's see.
You may have left your voicemail, Your Honor. When I took a break earlier, I had some phone calls, but I didn't have a chance to check them.
She does have a bond. She's got her uncle is hanging up on the back wall,
Yes.
right behind Mr. Elkins. You probably knew this young lady, Mr. Morford, I'd say.
I didn't hear you, Kat.
I said, you probably knew this young lady, Heather Chin's, Brenda Bird's daughter, and
Yes.
Charlie's niece.
I knew all the things.
Okay, I'll send this to Mr. Sowers. Said, what did I said, the April 21st was the other one? Yeah, it was April 21st.
Yes.
Bond forfeiture, April 21st.
State of Ohio recalls Michael Trogdon, case number TRC 23-5, A, B, C, and D. Michael Trogdon.
See the
I saw it, Your Honor.
Okay, well, we got work to do. Mr. Trogdon, how do you pay for medical services? Do you have a West Virginia medical card?
Yes,
Okay. Do you live in Huntington now, or where do you live?
Huntington,
Riverview Lane?
yeah,
Is there actually a view of the river from where you live?
yeah.
Where is, I don't know where Riverview Lane is.
It's actually, you know where the Western Regional Jail is?
Yes.
That's at one end, and you come through Altizer. I'm right in the middle between the jail and Altizer.
Okay.
It's
What's the name of that road? Believe it or not, I know that road pretty well. Been on
I don't know the name of the road, but the name of the one I live off, it's like right in the middle, before the tunnel and
I ride my bicycle out there.
yeah, me
So
too.
you see somebody on a
I
bicycle
used
going
to,
over.
I used to when I had use of my legs.
That's the Barbersville loop. go out there, make a right, go through Barbersville.
That's where my kids went to school, at Barbersville.
Well, we need to get you got a lot of things here we need to address. One of the ones you tested positive for is killing people right and left.
It's what?
You tested for something that's killing people all the time, fentanyl? You probably heard of fentanyl, haven't you?
Yeah.
You tested for that. You may not even know you're getting it, but that's the problem. People are putting it on stuff. You think you're getting one thing, but you're getting fentanyl with it. And it can kill you really easy.
They used to have me on so much medicine, like the Oxycontin and stuff, and then
They actually might give you fentanyl, I think, if you're getting a surgery or something, but I don't think you'd get it otherwise.
but I don't,
Morphine, you tested positive for morphine.
and then,
No methamphetamine though, that's like the #1 drug here these days.
I just keep I take what I have to be able to walk and stuff.
Well, do you think you're prescribed morphine? You're not prescribed,
I
you have a
guess,
medical card for or
I don't know if it's morphine, I don't know what's in oxycodone and the hydrocodone is what I'm prescribed.
tested positive for ecstasy, fentanyl, morphine, THC.
I also had neuropathy in my feet and legs. It's like little needles sticking in there all the time.
Where do you go to the doctor?
In Barbersville.
Who?
My doctor is, it's hard to say that name.
Does your doctor prescribe you your medications? One doctor, or you got multiple doctors? One? Family doctor?
Family doctor. I'm getting ready to start going to the one at the pain specialist in St. Mary's here next month. They had that down a lot when they had the pandemic went in, so they just waited to get me into there.
Okay. Have you ever had any kind of substance use treatment before?
No.
No? Well, I'd like to see your prescriptions, see what you're being prescribed. I mean, I guess it's possible. I know fentanyl is used in some medications, but it was my understanding it's like under a really controlled environment, like the surgery suite or something like that. I don't think.
I'll be honest.
Outside.
I'll be honest with you. I sometimes I get something off the street because I can't get up out of bed. I'm just being honest with you.
Okay. Well, I appreciate that. And here's the thing: if you get anything off the street, you don't know what it is.
That's what I've realized.
They can tell you one thing, but it may have fentanyl in it. That's happening a lot. You're not the only person that's happening to. And it's dangerous. It's really dangerous for you to take drugs off the street.
Yeah, that hydrocodone, or oxycodone was pretty stout. Used to be.
You didn't even test for that.
I know, that's what they used to give me, and I told them no. I told them I didn't want it no more because they was giving me 6 of them a day, and they was giving me what was this? Xanax with it, and my one doctor told me that those 2 drugs together can kill you, and now that's when I got the new doctor.
Well, we need to get you in someplace, and you need to take this with you and show them what you tested for. Valley Health, have you ever been to Valley Health?
Valley
They've got a
Health.
facility pretty close to you.
Yep.
There's one on Route 60, there's one on 3rd Avenue.
Yep. I've been there.
Okay. Well, they work with us, and they can help you with these kind of things, so maybe that's a good alternative for you to go to Valley Health for treatment. Okay, so anything else, Mr. Hill, anything?
No, Your Honor.
This is dangerous stuff you're taking. Okay, so, on this ODI, well, we got a refusal on this too. Tell me about, did you refuse to take tests?
Yeah, I did.
Okay.
We were gonna.
The reason why.
Delay sentencing, let him
Oh,
get
you want to
treatment.
delay it?
I think that given what we found out, maybe some intervention would be called for.
Okay.
The reason
I'm
why.
gonna let you go get some treatment, and then I'm not gonna sentence you, and the better you do in treatment, the better I'll do on your sentence. I want you to get clean.
I can't hear very well.
I want you to get clean, so I'll do better on your sentence if you show me you're gonna get clean.
Okay.
So go to Valley Health. You know where Valley Health is?
Valley Health.
Valley Health.
Do you know where that is?
Yeah, on Route 60.
Okay, you need to go there and get an appointment to get an assessment.
I built that building.
Okay, well, you know where it is then.
Okay.
When would you like to come back, Your
A
Honor?
month?
I've got the 21st of April is about a month out. Is that a good day?
April 21st for sentencing. Yeah, can you get him a copy of the screen to take with him? Mr. Spire?
If I can get a copy of it, yeah, I'll take
one of
it.
the file. I want you to take a copy of your screen. You give it to your doctor, give it to Valley Health, both. They both need to know what's going on.
So meet me out front.
Okay.
And make sure you understand the.
I'll try.
Okay. That's all I can ask.
May I approach you, get that paper?
Thank you.
State of Ohio versus Ryan Mount at the Lawrence County Jail. Case numbers TRC 19-2270 A and B, TRC 20-2545 A, B, and C.
Okay, we need Ryan Mount at the jail.
Your Honor, it's my understanding that he had a case bound over to the grand jury yesterday with a high bond. So I don't believe he's going to be able to, in the immediate future, participate in any treatment. I think he's going to be probably remaining at the jail.
Okay, so let's, when do you want to continue it to?
When's the next grand jury?
Well, I think it's coming right up next week.
Do you think this case will be on it, or do you think it'll be on the next one?
The one from yesterday, you mean?
Yes.
I think it'll be on this next one,
So
but I don't know.
should be an indictment next week.
Believe so.
Maybe come back on the 14th, that would give us a little bit of time to see, or we can come back next week for that matter, if you'd like, but I just don't know if
Well,
we'll
it's not going
have.
to be arraigned by then.
Well, it certainly won't be arraigned, but we might know if there's an indictment, we might not know, it might not have been released yet, so might be better to go a little further.
Is there a chance he wouldn't be indicted?
Ham sandwich and all.
I already put that on the record. I didn't hear any objection from the state. So. No, those grand jurors are absolutely independent. They only do what they want to do.
I'm here next week if you want to just put it on the docket. I mean,
All right,
it's just a matter of putting him on
Doesn't hurt. March 31st.
just a matter of pulling him up on the screen anyway. Thank you.
You're welcome.
The jail's notified them twice, and they did message Mr. Cooper back.
Okay.
Just that.
Is that all we got left? Is that?
Yes. State of Ohio versus Sarah Gravely, CRA 23-167. And Marion Holland is on deck.
So this looks like for arraignment, Sarah Gravely. Can we get him on the phone? All right, Mr. Mount, we've already continued your case because we found out you have a case bound over the grand jury. So there's nothing we can do today. We rescheduled for next Friday. We'll see, the grand jury is meeting this week, so we'll see if you get indicted. You've got a bond out of our municipal anyway, so you can't get out regardless of what we do here.
Okay.
All right.
Thank you.
So we need Sarah Gravely.
Sarah Gravely and Martin Holland.
Martin Holland on that.
Marion Holland.
Marion Holland.
Recording, you started.
All right, ma'am, are you Sarah Gravely?
Yes.
Ms. Gravely, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. Your hearing is being conducted here in my court. It's a hearing on an arraignment on a warrant. It's alleged that there's a warrant for you out of Hamilton County, Ohio, from the Common Pleas Court there. And you have a right to have a hearing here to determine if I should make you go to that county to face the charges on the warrant there. You have a right to remain silent. You don't have to say anything. If you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you want one. And you have a right to bond. Do you understand those things?
Yes.
Okay, do you understand the allegation that there's a warrant for you? And it looks like it's on some sort of community control sanctions violation. In fact, it says fail to follow the rules of community control. And the court issued the warrant because of that. So they want you there on this warrant. Do you want to have a hearing on whether I should make you go there, or do you want to agree to go to Hamilton County?
I'm just gonna agree to go.
Okay, so we'll send down a, it was a possession of drugs, it looks like, was your F5. So I'll set a bond on this. If you can post the bond, I'll order you to go turn yourself in. If you can't post the bond, I'm going to order Hamilton County authorities to send somebody here to pick you up. If I make the bond $2,500, which means you can either, if you got $2,500, you can post that. As long as you go to Cincinnati and show up there, you'll get your $2,500 back. If you can't post $2,500, I'll let you use a bail bondsman. So you have to pay them their fee. Usually it's 10%, so that's $250. But you lose it. You lose the $250, but then you get to go turn yourself in rather than wait for Hamilton County to come pick you up.
She's in our programs.
She's in a treatment
In
program.
Southern Oak.
We talked to her probation officer in Hamilton County. They want her transported from jail. They don't want her free to go.
Okay, well, I know what they want, but this is my call, so.
Right, yeah, they weren't, there was a big mess up, I guess, with TCC. That's where she was court ordered to go, but I guess they weren't getting reports and stuff from TCC, so they didn't even know she left.
Okay, since it's a felony file, I'm still gonna let her post the bond if she can, but she'll have to go and turn herself in. Do you wanna try to post a bond, or do you wanna me to order Cincinnati to come get you?
I would rather have a bond.
Okay, well, here's the thing, I'm gonna give you some time to try to post bond, but I'm not gonna order them to come get you until you see if you can post bond, so you're probably talking about the weekend. And if you can't post bond, we're gonna start the clock on Monday, not the clock today. So you wanna talk to the bail bondsman?
Yeah.
Okay, I'm setting your bond at $2,500, and here's the thing about the bail bondsman. If you don't go turn yourself in, he's gonna come snag you, throw you in his vehicle, and take you to jail. You understand that? So you have to go. Okay, I'll set your bond at $2,500. I'll give you until Monday to post it. So you gotta post it by Monday at 10 o'clock, 10 a.m. So that is the 27th. And then if you post bond, I'm gonna order you turn yourself in to Hamilton County before 8 a.m. on March 31st. Or, you don't do that, you gotta be in this court on March 31st at 10 a.m. Otherwise, I'm releasing this, the bail bondsman will be ordered to go get you if you don't do one or the other. You gotta show up in Cincinnati by March 31st at 10 o'clock or 8 a.m. or be here at 10 a.m. And if you show up here at 10 a.m. and you haven't gone to Cincinnati, I'm probably just going to put you back in the jail and order them to come get you. So I'm giving you a week.
I'm not TCC anymore, I'm a Southern Hope.
Well, okay, forget all that. That's out the window. That's all behind you because this warrant is activated. You've got to go back to Cincinnati. You got to go back to Hamilton County Common Pleas Court. You cannot go back to treatment until they tell you you can go back to treatment. So you can't just get out and say, okay, I'm going back to Southern Hope, everything's good. No, it's not going to be good. You got to go turn yourself into the court. The court says they want you back there, you have to go back there. You understand me?
Yes, sir.
Do you still want to try to post bond? You're just posting bond to drive yourself back to Cincinnati, not posting bond so you get to stay out as long as you want to stay out. And you got to do it next week. You got to turn yourself in next week. If you don't want to do that, then let's just start the clock. I'll give them a week to come pick you up. If you say I can't post bond, then I'm going to tell them, the sheriff, to say, folks in Hamilton County, you got to get here in the next week to pick this lady up.
Might as well do that.
Okay, so you're not going to post bond.
No.
Okay, sheriff, deputy, if you're listening in, go ahead and notify Hamilton County. She's available to be picked up. She's going to sign a waiver. I'm ordering them to pick you up by 8 a.m. March 31st. So if she's still in our jail, I don't want her released March 31st. I want her back here on a hearing. So if they haven't picked you up by next Friday, I'm gonna see you just like this on a teleconference, and we'll figure out why they didn't come pick you up, because something went wrong. And I might give them more time. If they have a good reason for not getting here, I'll give them more time to come pick you up. Do you have any questions, ma'am? Okay, you're gonna get this fax down to you to sign this waiver of your extradition hearing.
State of Ohio versus Marion J. Holland, and Wayne Johnson is on deck. Marion Holland, Wayne Johnson is on deck.
Sir, are you Marion Holland? Mr. Holland, this is Judge Capper, Lawrence County Municipal Court. You've got a new charge here, so I'm going to go over your rights with you first. You have a right to remain silent. You don't have to say anything. If you do, it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove the charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge against you is domestic violence. You should have received it already because it was faxed to the jail this morning at 10:41 a.m.
No, I haven't got it yet, sir.
Okay, well, it should be rattling around down there in the jail somewhere. So ask one of the jailers, where's my charges? I'm going to read, I'm going to read it to you. Okay, you did it right now. You can ask them later when we get finished. The charge alleges that on March 23rd of 2023 in Fayette Township, by threat of force, you knowingly caused Tanisha Sansbury, who's either a member of your family or a member of your household, to believe that you would cause imminent physical harm to her or a member of her family or her household. So that is domestic violence is the charge against you. The maximum penalty for it, 30 days in jail, $250 fine. You understand the charge? You don't have to agree with it, but do you understand it?
Yes, sir.
How do you wish to plead to it?
Not guilty.
Do you want a lawyer appointed?
Yes, sir.
Do you have a job?
No, sir.
Do you have no income?
Right.
I'm going to appoint Mr. Morford to represent you. Do you live with Tanisha?
No, sir.
And she's your sister, right?
Yes, sir.
You can stay away from her if I let you out of jail?
Yes, sir.
Your Honor, this took place at their father's residence, William Holland. And they said Bill here, I think it might be William. But anyway, he's 90 years old, and really, by rights, I don't know why we didn't get a separate affidavit for him as well. This same kind of thing happened in 2018. So we have grave concerns about Mr. Marion Holland being allowed around that residence at this point.
Where do you live, Mr. Holland?
With my dad, Billy.
Okay, well, the state's, can you get a hold, do you have any contact information for him, or?
I think we can, I would say we do. I don't know for a fact.
While he's looking for that, Mr. Holland, could I get your telephone number, sir?
You want my telephone number?
Yes, please.
That's your lawyer speaking.
740-894-0883.
Thank you. Thank you. Do you have the cell phone number?
740-396-3849.
Thank you.
Okay, I'm going to let the state check to see if your dad wants you to stay away from there. Do you have another place to go other than where your dad lives?
Yeah, I'd like to go to Columbus with my mom house,
What's her name?
Gabby Hughley.
Any objection to that?
No, Your Honor.
Okay, I'm gonna let you out on a signature bond. You understand what that means, right?
Yes, sir.
$1,000 signature bond. I'm gonna order that you stay away from your dad and your sister.
Okay, sir.
While this is pending, just while this is pending. And then come back to court. When do you want to come back, Mr. Morford? And we do have, if there's a time waiver, we can go longer, but this is on a short rocket docket otherwise, because it's an M4.
Sir, do you have any trouble extending the time period that the state usually has to try you while this case is pending? Or do you want to hold them to their time periods? If you're going to be out and living with your mother and you can stay away and not bother your father or your sister, I don't see any problem, and I would recommend that you waive your time so that we can fully develop your defense. But that's your call.
Yes, sir, I'd like to stay with my mom if possible.
Okay. Perhaps I should call him, Judge.
Okay. We'll let Mr. Morford call you, so if the jailer's listening in, could you hold him out so he can take a phone call here shortly? Then I'll finalize, I guess, the bond after that.
Thank you, Judge. I'll call him right now.
State of Ohio versus Wayne Johnson, case number CRB 15579, and Adrian Waldron Bishop is on deck.
All right, you're Wayne Johnson.
Yes, sir.
Mr. Johnson, it's alleged you missed a hearing April the 18th of 22 on a review of a failure to comply charge where you got convicted. Yeah, you were supposed to be here April 22nd. It's alleged you didn't appear. You've got, you have a right to remain silent. You don't have to say anything. If you do, it could be used against you. You can have an attorney if you want one, and you qualify financially. And the state has to prove this beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Do you admit or deny that you failed to appear for your hearing?
I did fail to appear. I was actually in a recovery program at the time.
Did you let anybody here at the court know that?
No, sir. I was. I'm not making any excuses. I just slipped my mind, trying to get my life back on track, trying to be a father to my child. My mom's not in good health. Life just snuck up on me, and this was one of those things that this case is, I think I caught it in 2015, 8 years ago, and I really haven't gotten in any other trouble since.
Yeah, how did you get back here? I mean, you got back here for, I mean, I don't think they came to West Virginia and got you on this, did they?
No, sir. I was actually in Riverside recovery there, and they kicked me out, and there was no reason why they kicked me out. I paid for a month to be there, and some of the other recovery patients there were, I guess making something to do. I just generally keep my head down, worry about my own business, keep
keep my nose in the books, really, and, which made me a target. And, I got kicked out of that program, and I was actually going from that one to another one. When, the police pulled up, they asked me if I wanted to ride. I actually forgot that I had this mentor, so I accepted, and I got in, and he ran my name, and I was here.
When did that happen?
That was 3 days ago. I've been in jail 3 days now.
Okay. Which treatment program were you gonna go to?
It's just in time for others.
Okay. Not familiar with that one. Where is it located?
It's St. Cuyahoga County, where my daughter is, my sister is, and,
Cuyahoga? That's like that's a different state.
No.
Yeah, it is. That's Ohio. That's up north. How are you gonna get there? How are you gonna get to Cuyahoga County? The great state of Cuyahoga, they call it.
I was working a couple resources to try to get a bus ticket there. I called my family and everything like that. And the center was actually, they were finding someone with the time available to come pick me up. But I was just trying to make it as easy as I could on them and maybe, close a couple miles in the meantime.
Okay. Well, you did your community service back in 2015. So unless there's some objection from the state, I'm going to say his jail time will suffice for his fines and court costs and complete his case so he can go on to Cuyahoga County.
We don't object to that, Your Honor.
All right, your case is completed by the jail time you served. You're going to get released. Good luck on getting into treatment in Cuyahoga County.
Thank you.
You're welcome.
State of Ohio versus Adrian Waldron Bishop, and Garrett Bryant is on deck.
This is case number 23174, A and B. Ma'am, are you Adrian Waldron Bishop? Can you hear me okay? Okay. Can you move your microphone a little closer to your mouth? Just bend it up a little bit. Move your microphone a little closer. Your microphone. Yeah, there we go. There we go, because we weren't hearing you very well. Okay, the charge, well, let me tell you your rights first. You have a right to remain silent. You don't have to say anything. If you do, it can be used against you. You have a right to have a lawyer, to have one appointed if you can't afford one, to have bail, to make the state prove charges beyond a reasonable doubt. You understand those things? Okay, the charge, the A case against you alleges aggravated menacing that on March 23rd, you knowingly caused Crystal Sykes to believe you would cause serious physical harm to her person or property. That's an aggravated menacing charge. Maximum penalty is 6 months in jail, $1,000 fine. The B case, also alleged to have happened March 23rd in Perry Township, says that you knowingly caused Tori Sherrod to believe you would cause serious physical harm to their person or property. Also a first degree misdemeanor, maximum penalty, 6 months in jail, $1,000 fine. Do you understand these charges? Do you have any questions before you enter a plea? What plea do you wish to enter to these charges? You want a lawyer appointed to represent you?
If I do want a lawyer, how long does this process take?
As long as it takes. I can't give you an actual time, how long it will take. It takes, if it goes to trial, it can take a while. If not, it could be less, but there is no pat answer for that question. So it reminds me of someone asked Abraham Lincoln, how long should a man's legs be? And he said, long enough to reach the ground. So the case takes whatever time it needs to take to get done.
Okay, well, I don't know, I guess I can just tell you what happened. Is everything-
No, you can't. That's not what this is for today. You gotta tell me a plea. And your plea is your answer to the charge. And if you don't know what to do, you should enter a not guilty plea. That's the safest plea you can enter. If you enter a guilty or no contest plea, you're waiving all those rights I said you have as a defendant. Don't do that unless you really understand what's going on and you want to subject yourself to what could happen if you enter one of those pleas.
Okay, so not guilty would be the safest one?
It would. So I'll enter a not guilty plea for you. Do you have the money to hire a lawyer? Do you have money with which you can hire a lawyer?
No,
Do you have a job?
not currently, no.
Okay, well, you're eligible, if that's correct. You are eligible for a court-appointed lawyer. Mr. Morford, I'll appoint you to represent Ms. Waldron Bishop. Your lawyer is here in the courtroom. Mr. Morford, he's going to represent you. He's going to want to know your telephone number, ma'am. Do you have a number where you can be reached?
No, I mean, I have a cell phone number, but I don't have my cell phone.
Well, if you get out of jail, will you have your cell phones?
I hope I can get it back.
Where is it?
It's in the place where they took me from.
Okay, well, maybe we need the place they took you first.
The place where I came from, that when they arrested me, I left it there.
Okay. Well, do you have
All my,
do you have a family member that has a phone number that can reach you, that you can give?
I haven't been able to contact any of my family members.
Yeah, but you're going to get out of jail, and you can make a phone call. Who will you call when you get out of jail?
I really don't know, because I've been trying to contact my stepmother while I've been in jail, and nobody comes to me through the phone. I
Okay.
don't have family and friends around here.
What's your stepmother's name?
Charlotte Hayes.
Charlotte Hayes.
Charlotte Hayes.
Do you know her phone number?
304-548-7117.
And that's your stepmother.
Yeah, and I can give you my ex-husband, who's the father of my child. He works for the Wayne County Sheriff's Department, and he's a police officer there.
Oh, okay, well, that could be a good contact. What's his name?
Dean Bishop.
Steve?
Dean, D-E-A-N.
Dean. Dean Bishop.
Yes, Dean.
Dean Bishop. He's a police officer in Wayne County.
Yes.
What's Dean's phone number?
I don't know it offhand.
Oh.
I would have it in my cell phone, but I mean, you can contact the,
And it's the sheriff? Is it the Wayne County Sheriff's Office?
yeah, I actually think I have it right now. It's 304-272-6378.
That's the sheriff's office number.
Yeah, and just ask for Dean Bishop.
Rick Thompson is the sheriff. You know Rick? He was an attorney. I guess he still is.
Is there any way that you can have him call me if you don't want him?
Well, that's up to your attorney. I'm not going to have him call you, but maybe your attorney will.
Well, that's what I meant. I haven't been able to talk to my child.
Who has your child?
I'm not sure if he does or if my stepmother does, so that's why I was traveling, was because I wasn't gonna get my visit with him.
Okay. And your Crystal Sykes is not related to you, neither is Tori Sheridan?
They're my now ex-boyfriend's mother and sister that he lived with, that I've lived with for 5 years.
Okay. Well, what word to stay away from them? I'm going to word you stay away from those two people.
Can I get my stuff from their house though? All of my money bags, like I have money bags in their mom with my cell phone, all my clothes, everything in there, and my stuff too.
Only if you can do it without breaching the peace. You cannot go there and cause another fight. It'd be better to have a third party go there, a friend or somebody that they will allow in.
Would Deputy Bishop do that? Do you know him well enough to ask him to do that?
I'm sorry?
Dean Bishop is the name that I got. I may have misunderstood, but Dean Bishop is the name I got as the Wayne County Sheriff's Office.
Yes.
The deputy, you know.
Yes.
Is that something you feel comfortable asking him to do?
Yeah.
Okay. And if you don't mind, can you tell me Charlotte's number again? Was it 548-7137?
No, 7117.
7117. Okay, thank you. Judge, I don't mind the call.
Okay.
Deputy Bishop and ask him if he can assist her managing.
And he's related to you, right? This Bishop guy's related to you?
He's my ex-husband.
Ex-husband? Father of the child. Okay. All right, I'm going to let you out on a $1,000 signature bond. And you don't have to pay it. You're just going to sign something saying you promise to come to court. And as long as you do, you don't have to post the money. If you don't come to court, then you have to pay the $1,000. So you're getting out without posting any money. You've got to come to the court in Chesapeake. It sounds like you're not from these parts. Are you from Wayne County?
No, I'm from North Carolina.
Oh. But I've got a South Point address for you.
Yeah, that's where I've been living for the past 5 years. About the area around it. I'm not familiar with Ironton or Chesapeake or anything. I know where Chesapeake is.
Okay, well, if you can find Chesapeake, you can find the court, because it's not a very big town. Chesapeake ain't that big a town. So, County Road 1, old US 52, the court's on that. You have access to a computer?
Not right now.
I know not right now, but once you get out of jail, will you have access to a computer?
I hope so, but I really don't know where I'm going to go. My ex can help me out.
Well, I was just gonna say, if you get on the computer, you can pull up the court and get the address,
I
but
think it's right there by the bridge, like the Chesapeake County Bridge, isn't it?
no, that's the mayor's court.
Do you know the flea market used to be the Tri-State Drive-In in Chesapeake?
No, she's from North Carolina, she's not gonna know that.
I'm sure that I can find it at some point. If it's not like tomorrow, I can be able to figure it out.
Next Friday, let's set it for next Friday. So your hearing in court is next Friday, 1 week from today.
Okay.
You have to be here at the court in Chesapeake at 10 a.m.
Okay. I wish I could write that down.
Well, maybe the jailer can write it down for you. It's not that hard to remember. 1 week from today,
At
10 o'clock.
Yeah.
10 a.m.
Yeah, I understand.
Okay, any questions?
No.
Okay, you should get out of jail here shortly. We'll
When
send it.
when will the lawyer be contacting me?
Lawyer, when will you contact them?
I will try to contact you later on this afternoon. If not, it'll be over the weekend.
Well, the only problem is you don't have a phone that you,
Yeah, I've got to get you got to get out of jail and get to a phone before I can call you first.
I can give you my cell phone number in case I do get it. Sorry.
okay, go ahead. Okay.
740-744-7877.
Okay, and that is your cell?
Yeah.
Is that in your property there at the jail?
No, it's at the house where she was before.
Okay, so you'll have to have the deputy get that for you, for somebody else.
Yeah.
Okay, any questions, ma'am?
No.
Okay, we'll send the paperwork down shortly for you to get released.
Okay.
State of Ohio versus Garrett L. Bryant, case number CRA 23166. And Marion Holland is on deck.
Are you Garrett Bryant?
Yes, sir.
Mr. Bryant, I'm Judge Capper, Lawrence County Municipal Court. Your hearing is here today. It's hearing by teleconference, and it's all being recorded. You say you have a right to remain silent. You don't have to say anything. But if you do make statements, it's on the record. It could be used against you. You have a right to bail to make the state prove these charges beyond a reasonable doubt. The charges here are actually in Franklin County, and what's happening is Franklin County is saying they want you to go to this court, to Franklin County, to the court on these charges. So you have a right to what's called a Rule 4 hearing. It's a hearing to make sure there's a good reason to make you to go to Franklin County, and you have a right to have an attorney represent you. The complaint alleges on March 31st of 2021, you knowingly possessed a syringe containing methamphetamine on the Ohio State campus. So that is a felony of the 5th degree.
Yes, sir.
And the maximum penalty for that is a year in jail, $2,500 fine.
Okay. I would just like to say that I signed what's it called, a waiver, whenever, expedition, when I was in, when I was in Western Regional Jail, in Barbersville, and they never did come to get me. They released me, due to a dismiss in the charge, and they never did come to get me.
Do you have
a waiver?
Do you have charges here in Lawrence County also?
No, I don't. They were dismissed. That's what I'm saying. When you all filed when I got arrested and picked up on this warrant with the cause, I had another charge added onto me. You guys, let me know what my charges were when I arrived at jail. They also worked with what they charged me with. They dismissed it. And I signed an extension to continue whatever it's called. And, y'all never picked me up.
Okay. It sounds like you need a lawyer then.
Okay.
Do you have the money to hire a lawyer?
I'm sorry?
Do you have money with which you can hire a lawyer?
I don't have money, no.
You're not working.
No, I am working. I am working at Walmart. I am. Good ways there. I have been.
But you've been incarcerated for a while now, right?
No, that's where you're confused. After I was incarcerated for 4 months after it was dismissed, that was a year plus ago. That was in December of 2021 or 2022. That being said, I've held a stable job for the last half a year, and I've been working at Walmart. Got hired on hours, it's actually been okay.
How long have you been in jail this time?
1 day.
Okay.
1 day, today, not even a day, it was today. It was just, I knew that, there was some mishap with these charges because I had signed an execution, like I said, and no one was there. Maybe they just released me without contacting you guys, I don't know. I don't know what the case was.
Well, apparently the warrant is still out there, because that's what we have here today. How much do you make at Walmart?
I make about above 1,000 every 2 weeks.
Are you paid by the hour?
I am paid by the hour.
How much per hour?
14 an hour.
Okay. How many, are you working a lot of overtime?
I'm working 40 hours.
Okay, so you're making about 29,000 a year.
Yeah, something like that.
Do you have any children?
Yes.
How many?
One.
And you support that child?
Not currently, no.
Is the child in your household?
No, I don't support it.
Okay. Can you look this, well, can you see if there was a case? You said there was a case in Lawrence County before?
Sorry?
You said you had a case in Lawrence County. That's been some time ago. Here's the problem. Franklin County still has a warrant out there, apparently. So if they withdraw the warrant, then I can let you out. As long as they've got the warrant, I've got to honor it.
No, sir, what I'm trying to say is, I wasn't arrested in Lawrence County, I was arrested in Barbersville.
I understand that. But you told me that you were Western Regional, they contacted Franklin County and they never did come and pick you up.
Right.
Okay.
Just look at the,
Well, maybe they just didn't want to go out of state. I mean, that could be that they haven't had a rule that they wouldn't come out of state to get you.
my trial got continued, and it eventually turned into a dismissal. I was released shortly, so I was just released. No one ever informed me if I had to come back. I think it was paperwork, rather than standing for.
Okay, well, I'm going to have our prosecutor check to make sure that the warrant's still outstanding.
All right, sir, I appreciate that, please.
Then we'll have you back after we do that. You want to follow?
Thanks.
State of Ohio recalls Marion Holland, case number CRB 23171.
You've had a chance to talk to Mr. Holland,
Yes, sir.
and how do you want to proceed?
He's ready, willing to waive time, Your Honor. He is planning on going to Columbus and staying with his mother until this is resolved.
All right, Mr. Holland, I'm going to let you out on a signature bond of $1,000, and then you would prefer to come back maybe a month or more, maybe that May 1st date?
Yes.
And I'm ordering you stay away from your dad and your sister. You're going to go to Columbus and stay with your mom, right? So you're not going to be around them anyway.
Yes, sir.
What was the sister's name? Tanisha?
Tanisha Sansbury.
Okay, I'm going to set your next hearing for May 1st.
Okay, sir.
May 1st, you got to be at the court in Chesapeake. Do you know where that is?
Yeah.
Okay, that'll be your next hearing, and you have his contact information?
I do, Your Honor.
Any questions, Mr. Holland?
No, sir.
Okay, that's it for you.
Thank you, Your Honor.
Very well. Okay, the only thing we've got left is the gentleman that had the Franklin County warrant that they're going to check to make sure is still outstanding.
Brittany Hines isn't on for today, Your Honor.
So we'll come back to the jail once we get the information, the prosecutor gets the information from Franklin County. Meantime, I can meet with volunteers. got some other people coming shortly, so.
So Jailer Garrett Bryant is on deck. He's the last one to be called, Garrett Bryant.
So court's in recess.
Oh, I'll be here. I can't go anywhere. I can't go anywhere until court's completely over, so I'll be here still.
Thank you. Proud of you.
Thank you.
Hey, Ron, I sent you a text. Free breakfast in the morning, 8 o'clock. Telecraft degree inspection at Proctorville. Yeah, that'll be pretty good.
Eric, this is Ron James, I report up in Chesapeake. Is Nicole in? Okay, and Missy's not there today, is she? Okay. Yeah, I need to speak to Nicole if she's there. Okay, thank you. Okay, that's fine, no problem. Okay.
That's what threw me, I was like.
Or, yeah, that's fine, I'll keep her extension if I need to call it on. Okay, bye.
You're even being more positive than I am, so I was like, really?
Nicole, this is Ron James, I'm a bailiff at Lawrence County Municipal Court. Judge Capper has asked me to get in touch with you to find out a little about the Kara Herman case. He asked me to call in and this reported last week, and I understand you've been assigned that case. Please give me a call at your earliest convenience at 304-634-7692. Thank you. Yes, Ron? Yes, it is. Oh, yeah. So how you doing down there, Nicole? Okay. Listen, the case I reported last week, that Kara Hearn, the judge was wanting to find out if you guys recommended that she go to inpatient or what. Yeah, now, her screen that we did on her today was a little bit better. There was a couple of things that wasn't in it, that was in it before, but there was still a lot of stuff in it. Okay. Okay, okay. And I'll tell the judge that you guys do recommend that. I don't, she's already out of here today by now, but, he's gonna have her back here, for this next Friday, next Friday, yeah. Okay. Right, okay. Yeah, now we had court today. Right, but she's scheduled to be back here next Friday now. Okay, so, oh, they called you, okay. All right, that's where we stand. I'll let the judge know. All right, now, just to let you know, and I know that this may have only happened yesterday, but the judge, if a case comes from court down there to you guys and you take it, he'd like to get a report like as soon as you see him about what's going on with it. Okay, so that was the first time that you'd been out on the case was this morning? Oh, okay. Okay. Okay, thank you. Good.